Who just did that?
I don't know.
That's cool. Let me fire something up.
All right.
Please keep in mind, responses provided on the program are merely intended to offer guidance and should not be construed as any individual situation sufficiently to know what the most prudent course of action is. So NARSOL advises all to consult with an attorney in their jurisdiction to determine the best course of action.
Welcome, everyone, to this edition. So, what is they used to say, the fruited plains, and from legislative session and other distractions. It's been several months since we've had a conference call of this nature, and it's well over hundreds. The first is that everyone misses my soothing companion. I couldn't. The more likely truth is that we have a great guest, and we would welcome some assistance in planning and promoting future calls. So contact us if you're interested. You work Bill podcast, and he's assisting as always this evening with production and hopefully making the program run smoothly. During the first hour, we'll be discussing the case of Murphy versus Roll, recently decided by the United States District Court for the Northern District of Illinois. Hour 2 will be, and during that hour, we'll try to answer your questions about whether a probation officer or registry tracking official is on you. And we're going to discuss anything that you want to ask about, can they do it? And hour 3 will be a conversation with the NARSOL Board of Directors, which is an opportunity for you to hopefully ask some questions and make a short statement about what you'd like to see NARSOL doing, or what we're not doing, or what we're doing well. And as always, when we have these long programs, there's a 5-minute break at the top of each hour so you can stretch and do whatever you need to do. Here are some spots and promos that we're running, and then we'll begin with the segment. And we plan to award some prizes this evening, at least a couple. Depends on how the spirit moves me, maybe more, but at least a couple prizes. And enter the contest by texting 227-4477. And you can just text anything that says prize or enter. So we'll have your number. And Andy will give you a contestant number, which will be 3 digits. And when we have the drum roll, when we pick the prize winner, that 3-digit will be a winner, rather than trying to find you on the telephone board, because it's going to be hard to find anybody tonight. So we will confirm. Andy will, if you haven't entered, will, and we're going to be giving away a registration to the NARSOL conference and a gift card. And if you've already paid to registration, we can either carry it over to next year, or it will be transferable to a future conference. We don't get on with what everybody came for, which is to talk about a case. So Adele Nicholas, who will be with us for the first hour, and we might have to stretch that depending on how many questions for the first hour of tonight's program. Ms. Nicholas is a Chicago-based civil rights attorney who has extensively litigated issues concerning registration and related collateral consequences in Illinois, Wisconsin, and among her recent notable cases, the village of Pleasant Prairie, in which the court enjoined enforcement of municipal residence restrictions, Winter versus Schmitz, in which the court prohibited the state of Illinois from labeling a creditor based on a misdemeanor conviction. And thank you for being here tonight.
Thanks for inviting me.
We have had you here before a long time.
Probably over a year.
So I never did ask you last time. There's a special individual that becomes an attorney, and all that's not the reason. So what inspired you to become an attorney?
Well, so I'm trying to think back. I guess that I worked at a legal magazine while I was an undergrad, and I wasn't sure what I was going to do after my undergrad, but I really enjoyed working at this. They spoke to me to go to law school, and then when I was in law school, I decided to me to represent people and help people with legal, and so that's what led me to where I am today.
Well, you have you've been doing a lot in this. I hope it story of your work. I mean, the group in Illinois is constantly sending me stuff about a case, and I say, guys, I can't even keep track of all the stuff that's going in. It's the other two states. So, can you tell us how many civil rights cases that you're involved in as either lead counsel or co-counsel that specifically deal with sex offender issues?
Sure. My colleague Mark Weinberg and I have been working on these issues for about, I guess, 4 years now. So it's been a big part of our practice. How many open cases we have, I'm not quite sure, but several. On cases in Wisconsin concerning GPS monitoring, in Illinois concerning the case we're here to talk about tonight, the imprisonment of people who can't find housing, that the cases about residency restrictions here in Illinois, Wisconsin, and Minnesota. And a couple of cases about just some of the occur here in Illinois. So probably at least 10 or 12 cases.
And for those who listen to these calls regularly, we always tell people these are enormous undertakings, but we'll get to that later. We want to focus on the case that we mentioned in the introduction to the program. What is the difference between a class action and individual as opposed to an individual action? We get this all the time. So you just, when you file a class action, you just walk into the courthouse and you have a little red stamp and you put class action and hand it to the court clerk, and that takes care of it, right?
Not exactly. So class action, which is a special kind of class action where you're not asking for money damages on behalf of the class, but you're asking for a class-wide injunction, meaning a court order that would tell the defendant to they've been doing, or that they're required to do something that they haven't done yet. And that injunction would be on behalf of everybody by a government policy that we allege to be unconstitutional. So that's how this case proceeded. We started the case with 6. We had 4 named plaintiffs who the court found had standing to represent the whole class. And then the case was certified by the action. Approximately 250 individuals who are currently in the situation that we were challenging in the case, which was they were imprisoned beyond their release dates because they could not find a place to live that the Department of Corrections would approve, and they were facing a particularly bad situation of potential lifetime imprisonment because their MSR time would never start to run because they had, and due to several quirks and intricacies, they ended up serving this time with no end in sight.
For those who are not familiar with the jargon, the MSR is mandatory supervised release that follows.
Yes.
Can we, being funny that all you do is just stamp with red letters class action, what does it take to certify and some of the complexities where people will understand that you just don't stamp it with red?
Sure. Well, I mean, at the beginning, you do just kind of make the allegations that it should be of everyone else who's similarly situated. And then how do you show that the case should actually proceed as a class? Well, you have to file something called a motion for class certification, which the judge to take into account. The first one is that there's a sufficiently large number affected by the policy that you're challenging. So in our case, we didn't have any problem showing that because the state agreed that approximately that we'd identified. And then you have to show the court that common issues of fact and law affect everybody who's in your class. So that means that you could resolve their problem on a class-wide basis because it's not about whether something policy constitutional rights without too much attention having to be given to each individual person's circumstances. You have to show that the claims brought by your named plaintiffs are typical of the claims of everyone in the class, meaning that they don't have your class representatives and your class counsel will adequately represent the interests of the class. So that means that you have named plaintiffs who are about pursuing the case and seeing it through the end, have the necessary experience and expertise to assist the class in pursuing their claims. And then finally, for an injunctive class, you just have to show that the class action is, I can't remember the exact term that's used for it, but for practical purposes, that is the best way to resolve this problem because the suing the government entity you're suing has acted in the class. So if you make all of those showings, the defendant, whoever you're suing, has a chance to respond and object. An analysis decides whether the case should proceed as a class.
And you did get certified.
We did.
We're getting a little bit of garbling, Andy. I'm going to pause for a minute and ask you: are we getting this system?
But I think it's resolved at the moment.
Okay, thank you. Okay, well, these types of challenges can be very expensive to undertake because the state. How has your firm been able to underwrite the direct expenses as well as the massive amount of billable hours that accumulate in this that you're involved in? You do have to pay overhead, right?
There certainly is a lot of risk that goes into litigating a case like this. Without any, we don't know whether we'll eventually get paid. We hope to get paid through a federal law called Section 1988, which basically says that a prevailing party in a civil rights suit, so the plaintiff proves the defendant violated their constitutional rights, the violator of the constitutional rights should have to pay their attorney's fees. So that's how we get paid in a case like this. But it is a lot of work. You know, sometimes we put in 3 or more years of work, and it's a risk because if you don't win, not only do you lose all the time you put in, but whatever funds you had to put in to do things like file the case, take depositions, obtain transcripts of depositions, all the travel we did to visit with our clients and interview people who were affected by these policies. So it can be a lot of, for us, we really believed in it. We believed that it was a very serious constitutional violation that was affecting a lot of people, and it just couldn't stand. So seems
Well, it certainly is. Of the inevitable. What is the actual issue that we're trying to remedy in this case that you? Well, let's try to focus on the mandatory supervised release, the discretionary parole, because one didn't get out of prison. So what are we actually trying to fix here?
Yeah. So every state is a little bit different in how it administers post-release supervision. In Illinois, we have everyone who gets a sentence to prison for a sentence of imprisonment and a sentence of mandatory supervised release. Mandatory supervised release serves some of the same functions as, parole agent, who's your supervising officer while you're out. You have to comply with conditions and be on things like GPS monitoring, comply with basically what your parole agent tells you to do and restrictions that you're given. But it's very different from traditional parole because it is not early release from a sentence that you haven't finished. It is a separate sentence of community supervision. So in Illinois, the amount a person receives is set by statute. Convictions, the law here in Illinois imposes a mandatory indeterminate term of MSR. By that I mean it's this permanent amount of time a person will have to spend on MSR in the community of 3 years to life. Another section of Illinois law states that for any time a person remains in prison while on this 3 to life term of MSR will toll the running of the time. So if a person is revoked for some reason, their MSR time stops running. The problem our clients had, and hundreds of other people were also having, is to live that the Department of Corrections would approve. And because they couldn't find a place to live, they were deemed to be in technical violation of the rules of their supervised release. And so they were revoked, quote unquote, although they never actually left the prison. So people were and still are being detained in prison beyond their mandatory release date. And that time is counting for nothing. It's not starting to run. They're not receiving any credit for it. It's just in prison, considered to be in violation of their MS. So very often, more often, it was simply because sufficient funds to pay for with all of the burdensome rules and regulations about where someone can live while they're on MSR for a sex offense. The IDOC just won't let you out. Situation that our clients found themselves in, and it's particularly frank. Unlike for a person year or 2 years or 3 years, someone with life can never max out their time. So people were potentially serving like no criminal judge imposed. They were unable to identify house.
So what agency actually imposes these conditions of mandatory supervised release? How does they, when they're ready to leave or getting near the end of their sentence, I'm assuming they get some notification of here are your conditions. Who decrees those conditions?
Yeah, so I'd say there's 3 entities involved in the conditions of MSR that people in Illinois face. They're formally given conditions by the Prisoner Review Board, or also called the Parole Board. However, those conditions aren't really decided because they are imposed by statute. So, along with restrictions that everyone on MSR has to comply with. There's a list that's particular to people who've been convicted of have a special set of statutory restrictions. So the first source of these restrictions, the lawmakers of Illinois, imposes the statutorily required conditions along with any other conditions necessary, circumstances or their offense, or where they'll be paroling to. And then finally, the Department of Corrections, its parole department, can impose on people. They call these instructions. So technically, a parole agent is only supposed to give instructions that are consistent with the conditions set by the PRB. But the instructions that are given by the parole very onerous in and of themselves and can impose additional barriers to people's ability to find housing.
Can you give us some examples of other states? What keeps people in prison?
Sure. So many of the restrictions are familiar to people anywhere. There are geographical restrictions. In Illinois, there is been convicted of a child sex offense may not live within daycare, including home daycares. The Illinois Department of Corrections to anyone who's on parole for a second, even if it wasn't against a child. There is restrictions on housing, including not being allowed to live or other types of places where they believe. There are restrictions been imposed just by the people were not allowed to live somewhere that had internet. People, children also live, or where children, people are not. Their corrections prefers a landline phone for electronic home. Hands of the parole agent, including you to live at a residence with a dog, they're free to impose. And it's not, in my estimation, it's not sufficiently constrained when they go to investigate a place. Someone even has photographs of their own children enough for the parole agent because of the presence of that, or for instance, toys, children's could be enough for a site to be affected.
Sounds like it could be potentially with an agent who does the site inspection.
It is a serious problem, the amount of discretion individual parole agent, and that's something that I think we really came to understand through litigating this case, is that it varies greatly depending on who does the investigation and what that individual takes into account. I guess another restriction that we should talk about is there's a statutory restriction on anyone who is on MSR for a sex offense from living in the same building or apartment complex as a person who is on the registry. The DOC, up until very recently, was also applying that restriction to someone who was to live there was not permitted to parole a trailer that was in a trailer park where another registrant lives, even though that is not required by Illinois law. But the one good thing to already come from this case is that the Department of Corrections has withdrawn that rule. And so now people are permitted to go to even if another registrant lives there.
Oh, well, I'm nearing the end of my question, but I'm going to ask you about. I read the opinion, most of it. I didn't read the background on all the plaintiffs because it was quite detailed. But the court noted that a particular plaintiff, Paul Murphy, the court noted that he's indigent and homeless, and he was originally convicted of possession of child porn in 2012 and received a probated sentence. And now, 5 years after his release date and nearly twice the number of years of his sentence, he remains incarcerated because the Department of Corrections cannot find a place for him. How we've covered the supervised release sufficiently, so I'll skip that part of the question. But did the fact that the clock does not start ticking until the offender can get out of prison, how heavily do you think that weighs? Because, like in my state, credit, which is equally appalling to me that you can serve all your time and have to life. The 5 to 20 years, you could conceivably serve 20 years and get out. But these guys could never get out if they can't find housing. Do you think that was a significant fact that the court considered?
I think it had to play a role, although that was not specifically the basis of the judge's decision. It did play a role that for someone like Mr. Murphy, who's older and doesn't have family that he is in touch with, doesn't have friends on the outside, and doesn't have any assets of his own, the situation is just so dire. He has no way of getting the funds to go somewhere. He was facing, the rest of his life behind bars on a sentence, was originally probation.
It's really appalling. Well, what happens next in this case? Because I'm going to try to get at least a half an hour for callers. What happens next? Will the state appeal? What will anybody get released? Where are we going with this next?
So we're very heartened by some developments we've had over the past, which is that the state, the attorneys who we've been working with on this case have reached out to us and said they're interested in reaching a solution to this problem. So we've agreed, and they've agreed to engage in a voluntary process with the judge, Judge Kendall, who ruled on our motion. So I guess we didn't actually say what the decision was in the case, which was that Judge Kendall found that this whole scheme of keeping people imprisoned indefinitely because they can't find somewhere to live violates their constitutional rights under the Eighth Amendment and the Equal Protection Clause. And the basis of her reasoning for that is that it's essentially punishing them for their poverty, which is a violation of their constitutional rights. So based on that, the state wants to sit down with us and engage in a process to come up with solutions that will actually give these people an opportunity to identify places outside of prison to serve their MSR. So we're encouraged by that. It could take a lot of forms. We have some ideas of what would be potential solutions, but we won't know for another couple of weeks what's going to be achievable without legislative change. Because, as of right now, the judge has basically ordered, you can't do this. But what she hasn't said is, here's what you have to do to fix it. So that's what we're hoping to achieve. And we have our first meeting with them, with, the representatives of the state and with the judge a week from yesterday, May 1st.
So, well, I'm going to conclude my questioning, and we have an unusually large number of attorneys on tonight. I'm going to go ahead and unmute. I know Janice is here, and I'm getting ready to unmute you right now. And then any other attorney that wants to ask a more directed legal question, go ahead and I'm going to switch to this is the complicated thing here is we have a bunch of mics to reopen as soon as I switch from lecture to Q&A. But any other attorney that would like to ask a question specifically, I'm going to allow the attorneys to go first. But now, attorneys, you love to talk, so try to ask a very concise question so that we can get to as many people that are waiting to ask questions that are from Illinois. So I'm switching to Q&A. Andy, are you ready to do the opening the mics of everybody who has to be reopened?
Q&A session has started. Muted.
I've got Janice unmuted. Welcome, Janice. Janice, can you hear us? Well, her mic is open. If she does get back, she may be stepped away.
Larry?
Yes.
Larry? Hi, this is Janice Bellucci. Did you just mention my name?
I did. I said that I'm unmuting attorneys, and I recognize that you're here. So if you did you have a question for Adele?
Okay.
Then any other attorneys that want to get in the queue, we're gonna let
Sure, I do.
attorneys.
Of
So
course.
hi, Janice. Welcome to the
Hi.
call.
Well, thank you. And I really sincerely want to thank Adele for taking on such an important and huge issue in the state of Illinois. I only became aware of this about a year ago, the issue. And when I first found out about it, I quite frankly couldn't even believe it. But I will say, or having said that, I will say that this is how people who are considered sexually violent predators are treated in California as well. So even the ones that are considered healed and ready to reenter into society, they still can't get out unless, I guess, similar to what's happening there in Illinois, you've got to be able to prove that you have a place to live. So I guess I'd like to ask Adele, though. Adele, what would you say has been the biggest challenge for you in this lawsuit so far?
I think the biggest challenge was putting together a convincing case for the judge that was comprehensible, because it's not one law or policy that you can point to. It's an extremely complicated, overlapping scheme of laws, regulations, policies, unwritten policies, just the way things have been done, that all, when you put it together, it creates this impossible situation for our clients. So I think that some, other attorneys have worked hard on this issue too, but where their cases ultimately weren't able to succeed is that I think a judge is able to point to maybe one star in this constellation of laws and regulations and say, well, that in and of itself is reasonable and rational, and it's designed to protect the public and foster people's success on MSR. So I think that was a big challenge to put together a broad enough case that really explained how all of these complex systems were interacting.
So,
well, I think you did a great job doing that.
Thanks.
Janice, I'm going to leave you unmuted as long as you're on a quiet background in case you have anything else to interject. Any other attorney, *6 will get you in the queue, and I've got one in the queue right now, so I'm assuming this is an attorney. So go ahead, you're on NARSOL in action. Are you a legal professional? Christian, 847 area code. We're either having a problem or he can't hear us. Okay, well, let's move on. Anyone in the general audience, if you would like to ask a question for Ms. Nicholas, *6 will get you in the queue if everything's working correctly. We would ask that if you're in a state other than Illinois, we'll try to give Illinois callers preference. So Illinois residents or people connected with this issue in Illinois, go ahead, hit *6, and we'll start taking questions. So I got another one here that says, Mason, you're on NARSOL in action, area code 815.
Hi, Adele. My name is Jesse. I was recently in Taylorville with quite a few of these, matter of fact, probably all of the people that you're talking about that was in this case. So I've been following it for a few years. I'm out now. I'm in Ottawa, Illinois. And my question, I guess, would be this 3 to life, for instance. Is it going to possibly change the life part? Are you guys trying to get that thrown out so we can be on 3 years parole and get on with our lives?
Well, I anticipated that this would be the first and probably the most frequent question. And the real answer is that no, this case does not get rid of the 3 to life amount of supervision. It's harder to challenge that from a legal standpoint. And this case did not attack that. This case attacks the fact that people can't get out of prison on MSR. So we are monitoring the process for people to actually finish this term of MSR. So what does it take to actually petition to terminate your supervision? And we're interested in that issue and we're watching it. in terms of whether we have a legal challenge to the constitutionality of 3 to life supervision, no. At this point, it's still intact.
Okay. Thank you.
So, all right, thank you. And I'm going to put that one back on mute. I have opened the microphone for Attorney King Alexander, who's going to be with us in the second hour. Can you hear us, King?
I can hear you. I don't know if you can hear me.
We can hear you fine. And then we've got one that says Oregon Judicial Department on here. I don't know if that person wants to ask a question, but I'm assuming that's an attorney. So, department, did you have any comments or anything before we go to the rest
I
of
don't
the
have
people?
any questions.
Okay, thank you.
No, I don't have any questions. I'm just listening and thanks.
All right. Okay, so I'm going to begin going to callers. Some people I won't be able to give your area code because it's not giving it to me. So I'm going to, I know this next one is an old area code 312. You're on NARSOL in action. Anybody who would like to ask a question, hit *6 and we'll get to as quick as you can. So go ahead, area code 312.
Can you hear me?
You're going to have to speak up just a tad.
I said hello. Can you hear me?
We can hear you if you maintain that posture.
Okay. Hello, Adele. It's Will from Illinois. How are you?
Hi, well, thanks. How are you?
Good. So my question for you is, I know that this lawsuit and this decision was pretty narrowly focused on the 3 to life issue, but in the decision and in the statements made by the judge, it just seems like that there are elements that might be able to translate into other lawsuits or other efforts that we're doing. Can you talk a little bit about how you think that this decision and the comments made by the judge might help in other lawsuits or efforts that we're doing?
So I think that's an excellent question, because it's true that the judge's decision was based on this concept of punishing someone for their poverty. And that applies not only to people who have indeterminate MSR, but it applies equally to people who have determinate terms of MSR who end up having to run out that time in prison simply because they can't afford a place to live. So we're hopeful, we haven't discussed this matter with the state yet, but we're hopeful that they will recognize that any relief that's granted in this case should also benefit those folks, because there's a lot of people who are in that situation. At any given time, there's probably 12 to 1,300 people was the last estimate that I saw who were stuck in IDOC on their MSR time simply because of a lack of housing. So I think that that language will definitely be helpful here. And then, I'm sure I can't think of it off the top of my head, but I'm sure there are other applications, where these laws do come down really harshly on people who just simply don't have the funds to find a place to live, or, other things. So the language may be helpful there too.
Does that take care of you, Will? I guess it does.
Yep, that was.
Oops, sorry about that, Will. I got a little too quick on the button, but you're going to be back on in the third hour. Christian, I'm going back to you. It looks like you're back in the queue. Go ahead. You're on NARSOL in action.
Hi, yes, this is Christine, and I just want to first say, Adele and Mark, you guys did a great job. I'm very happy of the outcome that it came out, and I appreciate everything that you guys did. I do have a brother that's in there. He is only doing the 3 years MSR right now, and he's supposed to be released in January. Does he still have to do the MSR after he gets released, or is that counting towards his getting out?
Does he have a determinate amount of MSR? Does he have
He's got 3 years. Out? He's only got 3 years, and he's got 3 years of MSR, and he's supposed to really be released January 17, 2020.
So if he's maxing out his time, if he has a determinate amount of MSR, so for instance, if he had a sentence at 50%, that MSR time also runs at 50%. And so if he has 3 years and he does the year and a half, or, the 85% of his 3 years, whatever's required by his sentence, he's going to be done, and he does not have MSR after that.
Okay, that's what I wanted to make sure, because I am picking him up at Taylorville, and I know there's a lot of gentlemen out in Taylorville.
Yeah.
I keep in touch with all the family, pretty much most of the family members that are in Taylorville right now.
Mm-hmm.
So, but I just want to say thank you again, Adele. You are amazing, and so is Mark, and so is Scott from Illinois Voice. I would not have been made it through this whole ordeal without you guys. I thank you so much.
Oh, thank you for saying that. I really appreciate it.
No problem.
Oh, again, I jumped the queue there too quickly. Thank you for. I mean, they stay on the call. I just silenced the microphone. If we have every microphone open, it would be so loud you couldn't hear a Mack truck. So I'm gonna take the call. The queue is full, so I'm gonna try to move expeditiously through. Area code 847. You're on NARSOL.
Hi, thank you very much. My name is Brian. I'm a resident of northwest suburbs of Illinois. With Adele, this might be a little bit outside the scope here. I've been trying to follow a little bit. Back in 2016, 17, I believe at the time Governor Rauner formed a task force to look at the possibilities of changing the registration laws and allowing people to get off the registry. Is your firm doing any kind of work in regards to trying to assist with that, or to help, I guess, enact these laws or get these laws enacted or anything like that?
Well, it's a great question. As far as I know, nothing has come of the task force recommendations, which is.
Yeah, I noticed that myself.
Yeah, it's disappointing, but I guess, someone else might disagree with me, but I was always pessimistic that anything would happen from this process. I thought it was a good idea and a good process, and I thought some of the recommendations that came from were not bad, but it's a tall, I think I'm preaching to the choir here, but it's a pretty tall order to get legislators to take any action on these issues when there's always the political risk that it will look like they're being soft on crime or, something of that nature.
Correct.
So as far as I know, there's really not anything that's come out of that. Although we'd certainly, be supportive of efforts to reform some of these laws. But I know our
Awesome. Thank you very
affiliate,
much.
Illinois Voices is interested in these issues and monitoring them closely. And so if they call upon us, we will try to help with those efforts as much as we can.
Thank you for the question.
Awesome. Thank you.
I see several wireless callers, and I'm gonna get to the wireless callers. And there's a one here named David, so it's going to be David, Don, and then the wireless caller. So David, you're next. You're on NARSOL in action. Go ahead. Area code 646. We're going to come
Sorry, I was on mute. Can you hear me?
We can hear you. Go ahead with your question.
Okay, great. I have two questions, actually. First, do you know how many states have a setup similar to Illinois where the residency requirements are keeping people in jail indefinitely? So, what's the scope of the application of this to other states? And second, do you think this might have ramifications for the debates over civil commitment, where, again, people are, after their sentence, being kept indefinitely, in that case, supposedly because they're still getting treatment, but in some states, no one ever gets out of these, and the treatment is either basically non-existent or ineffective. So do you see any link with those sets of issues? Thank you.
Yeah, both are good questions. So with regard to other states, someone should do, a 50-state survey of how these issues play out. What we know for sure is that there are many states where there's been a recognition that people have to be released from prison after they finish their sentences. So in Wisconsin, for instance, if someone can't find a place to stay, they're allowed to use a shelter as their address. and they're on GPS monitoring. And the Department of Corrections in Wisconsin considers that sufficient to monitor the person. Similarly, we know, Minnesota allows people, to get out of prison even if they don't have an approved place to stay. We are aware of some litigation in New York that's similar to ours, which is that people are not released if they lack an approved housing. But off the top of my head, those are the 3 additional states I can think of that I really know about with enough confidence to tell you what's happening. But I would be very interested to see how this is playing out nationwide. And then in terms of the civil commitment question, yes, I think many of the questions here are very pertinent to the situations of people who are on civil commitment. I think, as Janice mentioned earlier, some people who've been civilly committed are eventually deemed to have, recovered, or they're better. They should be released. And then yet the state still continues to hold them in something that's essentially prison, unless and until they find a place to live. So I think a lot of the principles articulated by Judge Kendall in her decision should be applicable to those situations too, where they arise, whether it's here in Illinois or elsewhere.
That's a great question. And since we're talking about states that may be similar, we're going to go to one where I think there is a similarity. We got a question from Don. Don, you're on NARSOL in action. Go ahead.
Thank you, Larry. I was going to ask, I know this is probably outside of what we're talking, the subject, but say a person has money to be able to, get a place. We're having trouble with, it seems like I see people that they have to have a sponsor to be able to parole out to housing. It would be nice if they could, if they found a house or apartment, should I say, to be able to rent it and being able to parole to that apartment. Are you having any problems with people who do have the money and the means to be able to parole to an apartment without a sponsor?
Well, yeah, I mean, absolutely. It's still incredibly difficult to locate a place. Even people who do have means struggle greatly. And I've talked to many families that are in that situation where their imprisoned loved one does have enough money to pay for a place. It's just they're submitting address after address after address, and they're being rejected for sometimes quixotic reasons that are difficult to understand. So, yes, we face that problem here. And I think that's got to be part of the conversation that we have here in Illinois is what process is going to be put in place to make it easier for people to find and get approval for housing.
And Don, that's a great question because it is a similar problem. People don't have a much higher barrier because they can't even present an address, but people who have all these erected barriers that are either statutorily or administrative or the whims of the PO, the parole agent, you end up with people who could be out of prison, but they're not. And that's a tragedy in the United States to have that happening. So, Don, we are very much looking at the similarities and considering such litigation in our state. So, and thanks for listening and being on the show, Don.
Thank you.
So we're going to go. Going to area code 916 on a wireless. It says wireless, no name. You're on NARSOL in action.
Hey, thank you very much, Adele, for what you're doing. You're instilling a lot of hope in a lot of people. My name is Mike. I'm on MSR, the extended MSR. I've been out for 5 years, and I just wanted to offer any assistance that I could as far as with what you said earlier about monitoring the release process. I'm having a great deal of trouble getting answers from my parole agents. I've had 4 different agents in the 5 years that I've been out. And, as you can imagine, you have to build a rapport with these people, and it takes a great deal of time. So I just wanted to tell you that just thank you for everything, and if you need any help, I would love to help you.
Thanks very much. I mean, I'm happy to talk to people who are currently on MSR just about the process and what their circumstances are in terms of trying to get off MSR, because there is theoretically a process in place that we're aware of in the Department of Corrections, but we're not clear on to what extent it's being followed, how it's being administered, and how it's affecting people when they're in your out for 4 or 5, or more years, and they're still on MSR. So feel free to, give me a call later this week or next week if you'd like to talk it over.
Thank you so much for listening.
Okay, yeah, that'd be great.
We're going to go to another wireless caller. This one's from area code 309. You're on NARSOL Action.
Hi, my question is, can you hear me?
Yes.
Can you hear me? Okay, thank you. When I heard about, when I first heard about this decision, I was really happy, for the people who were affected. But for me, as a registered sex offender in Illinois who is not on MSR or anything like that, one of the things that I was buoyed about was I thought that it might perhaps spur the legislature to, have to take up this issue, and maybe also take up, for example, some of the other issues that the person who talked about the task force talked about earlier. And so earlier in your comments, you had mentioned that there was this upcoming meeting with, opposing counsel or something with regard to a solution. And you had mentioned something about maybe a legislative solution, but then you had also mentioned something about maybe they were going to try to make some accommodations and things like that. So my question is, what do you think the prospects are that this issue will be addressed, by the legislature, or do you think that, this is going to be solely, dealt with outside of that process?
So
thank you for that.
Yeah, it is a good question. I'm always pessimistic that legislators will take any action unless they're forced to, but it very well could be that after this conciliation process we're going through with them, that the result is an order from the judge that makes enforcement of some of these laws no longer valid, which would require a legislative change. I'm not sure to what extent that's going to happen, and we'll know a lot more next week after we sit down with everyone. But whether the legislature will take this up voluntarily, I'm a little doubtful.
So, well, we're going to try to zip through one more call and give you some opportunity to make closing comments, unless you, of course, would like to stay over. So we're going to go to area code 847. I know this should be an Illinois call. You're on NARSOL in Action.
Hi, how are you?
Well, thank you.
Try to make it an expeditious question.
Okay, it's not so much a question as it is some aid. The caller from Ottawa, I think, was asking about the task force report, the Sex Offenses and Sex Offender Registration Task Force. Something I'm on MSR and 3 years to life, and something I've brought up in our mandatory group meetings and have not gotten a lot of success with is that to try to get something through, we all have to contact our local legislatures and start talking about this. And I've had some luck with my local legislator. He's new. He was just elected. And probably if you have a new elected legislator or representative or senator in your area, they may be receptive to speaking about it. Mine is. He's very interested in this report, and I've had a meeting with him, and I hope to have more meetings with him. And I think it's really important that we all take a part in our own environment that we live in, and we can do that really seriously by picking up the phone and calling our legislators, and do it often to keep reminding them that we're here. This doesn't happen by accident. So we have to help out. We can't, I mean, Adele and Mark work very hard, but I think we can help them a lot with this stuff if we get involved. So that's really all I wanted to say, because I think this task force report is really important. And actually the 3 years to life, the one caller earlier asked if the 3 years to life, people who are on 3 years to life MSR and they're living out in the world now, what's going to happen with that? This task force addresses that. You know, so if you're really interested in getting off, make the phone call and let's help ourselves.
So thank you for that. We're rolling into a hard break. I'm going to hear lovely music playing in a moment. But Adele, did you have any summation or wrap up you want to make before that lovely music starts?
I don't think so. I appreciate your giving me the opportunity to come on and share some info about the case and keep up the fight.
Well, we are delighted to have you here, and we will send out an email after the conference call and provide information for people who would like to contact you, and so you can follow up if you have a relevant question about the situation in Illinois. So we're going to be back.
Good.
We're going to be back after a 5-minute break to take up the second hour with King Alexander with Can They Do That? We hope everybody will stay with us, and we appreciate you being here this evening. And you're listening to NARSOL in Action.
Are you tired of hearing what feels like gloom and doom all the time? Tired of the message that there's no hope? That somehow life is over? Humans on the Registry, that's humans.narsol.org, has been launched with the goal of sharing some positive messages about registered persons. This project of the National Association for Rational Sexual Offense Laws seeks to bring a little light and hope and humanity to this difficult subject through short stories about registrants who are succeeding in spite of the obstacles in their paths. Are you a registered citizen who has a positive story to share? Have you found meaning, a better tomorrow, a loving family, built a new life? Come tell us about it at humans.narsol.org and show the world and other registered citizens that we all have reason to hope.
The National Association for Rational Sexual Offense Laws is NARSOL. NARSOL is the nation's largest and longest existing civil rights organization fighting for the constitutional rights of registered citizens and their families. NARSOL's work is made possible by the generous financial support of people just like you. In fact, without our members and donors, NARSOL would not be able to continue fighting against the evils of sex offender registries. NARSOL does not receive financial support from any government agency, corporation, or foundation outside of its own. If you believe that the work NARSOL is doing is important and vital and must be continued without interruption, then please make a contribution today by visiting our website and clicking the red donate button. Any amount you can afford is appreciated. No amount is too small. But please be generous. NARSOL is managed by a dedicated team of volunteers who freely give of their time and talent to help us all succeed. Together and with your help today, we can end the scourge of sex offender registries in this generation. Thank you.
The year is 2016. I had no idea things could even get worse. And in the last 3 years, they have gotten worse. Every year, we have more and more bills amping up restrictions, more and more presence restrictions, which we didn't have in 1994, residency restrictions, which we didn't have, loitering restrictions, more restrictions on employment, more restrictions on where you could live, Halloween, different holidays, what you could use, what you couldn't use. Smith v. Doe no longer applies. I think this is really what we've all come to agree.
Now more than any time in our history, we need people engaged because the stakes have never been higher. Georgia RSOL intends to educate the media, public, and legislators with facts, versus myths about sex offenders. Georgia RSOL wants to reform the laws pertaining to sexual offenses and the registry in Georgia. The failing policies for sex offender management need to change. For a safer Georgia, a broken system must be fixed. Citizens of Georgia, both registrant and non-registrant alike, need to take a stand. For the future of our state, leaders need to write and support, to be courageous, and support legislation that is truly for the best interest of the people, of all people, and the future of our state. Visit rsolgeorgia.org to become involved and make a difference. Please keep in mind, responses provided on the program are merely intended to offer guidance and should not be construed as legal advice. We cannot cover the specifics of any individual situation sufficiently to know what the most prudent course of action is, so NARSOL advises all participants to consult with an attorney in their jurisdiction to determine the best course of action.
Larry?
King, are you there?
Yes.
Okay, I was muted by myself. I apologize. Welcome back, everyone, for the second hour, and apologize for the snafu of not opening my own mic. For this second hour of NARSOL in Action, we're going to have King Alexander, who is the supervising felony without parole attorney in the Calcasieu Parish Public Defender's Office. This is your opportunity to ask a veteran attorney whether or not something can be done legally or if it potentially violates the Constitution. And if you can stay on for the final hour, we're going to have a conversation with the board of directors. We'll have several members of the board. I don't know how many actually are going to show up, but this will be the opportunity to make comments and interact with the board. But my first order of business before we go to the questions for the attorney is to see if we can find Richard. I've released your microphone, Richard, and you're welcome to talk about the upcoming NARSOL conference. Richard, are you there?
I am here, Larry. Are you hearing me?
We are hearing you. Richard is the chair.
Are you hearing me? Very good.
Is the chair of the conference planning committee, and he's been working diligently with the conference planners to put together a program. So what are we going to be doing in Houston, Richard? Is that thing coming together?
It is not just coming together, it has come together for the most part. We've got a few little details we're still working out, but I want to say, first of all, there are 10 people on the committee, and the great thing for me is that I only have to ask the questions and make sure that we get answers, and the other people always have the answers. So I'm really pleased to be working with this group. They're well seasoned, and we've got an exciting agenda. We've got Alyssa Ackerman, who's going to be talking about restorative justice. And of course, I don't have any of the names in front of me, so I'm going to hope that somebody, because I'm on the road traveling, and all my stuff is up in a room. But
well, just tell everybody how to find the website, and they need to go look at it if they haven't.
Well, If you go to the front page of NARSOL.org, you will find that there's a link there, or you can go to conference.narsol.org and you will get to us. And on the website, that you can sign up. If you haven't signed up, there is an early bird special that's still available. Although I'm hearing, Larry, that the room count is getting very high and that we're going to be possibly having to come up with alternative plans for rooms. If people don't get signed up right away, they may have to end up with the alternative plan. Is that true?
We have a high room count. It has not reached that point yet where there have to be a backup hotel, but we do have a backup hotel if it reaches that. But the more important thing for people to realize is that booking your room doesn't cost you any money. And the special rate we have, which is $104, it includes a breakfast bar for up to 2 people, and it's a very good breakfast bar. That will go away on the 15th of May. And when that goes away, you'll be at rack rate minus any discount that you might be entitled to, like AAA. And the rack rate right now, check today's matter of fact, they're quoting for those dates are about $125. So if you think you're coming to Houston, go ahead and follow that link and book your room. And you can always cancel because you don't get charged until you check out. So that would
Good
be
advice.
my promotion.
And we're really pleased. Our sign up is ahead of years past, so that's positive. And it's and I'm looking forward to being in Houston in June. I think you're going to be there, and a whole bunch of other people.
So thank you for that, Richard. I'm going to silence your mic because there's too much noise coming. But thanks for being with us tonight, and hopefully you can come back and stay with us for the final hour. Thanks. All right. So as I said, we have King Alexander, who is one of our regulars, who's going to deal with can they do that? And of course, the answer, King, is what? Can they do that? There's an easy answer. What is it?
Well, yeah, we can cut the whole hour short if I just give the answer on the front end. The answer is they can do it until we stop them, or they will do it. I mean, the more difficult question is it unconstitutional? Is there a cause of action? And what might be done legislatively to change?
So, I think the disclaimer is played enough time, so I'll dispense with reading the disclaimer about keeping in mind the responses or blah, blah, blah. But this is not intended to be construed as legal advice. Some common questions are, can they prohibit me from accessing the internet? Can they prohibit me from seeing my own children? We have a lot of new listeners, so some of these may have been answered before. Can they prohibit me from going to my child's ball game? Can a registration officer demand entry into my house? We hear these regularly. Those come to us in letters, and those are common, but you're not restricted. You can ask any question about something that you think they shouldn't be doing, and it's dubious. So if you have a question, it'll be *6, and that'll get you in the queue. And there's already 2 people in the queue, but we'll take them. And please let us try to do questions. And if we need additional information, the attorney will ask you for additional information. But the story really does cut down the number of questions we can take if you have to tell the story. So please try to do a question. So the first one is area code 207. You are on not Ask the Attorney, but you're on Can They Do That? 207, can you hear us? We're going to silence you and come back to you if you don't mind, and move to the next person because they're not hearing us, or we're not hearing them, one or the other. So get back in the queue. Area codes 660. You're on Can They Do That?
Hi, Larry. This is Carl from Missouri. Can you hear me okay?
You sound fantastic. You should be running this program. You have great vocals. You're
I
coming
could
through
definitely step up to the mic and deal out some BS if I need to.
Oh, well, I can hear those vocal windpipes you have.
I've got a really strange particular situation. I'm a U.S. citizen, and I'm currently married to a foreign national that works overseas. My question on can they do that is particularly regarding immigration and rights. basically the Customs and Immigration Office has denied my wife and her kids visit visas because they assume they're going to come to the United States and immigrate the wrong way. They're not going to leave. And on our petition for the normal citizenship visas, they've denied her and the children because they assume, according to like the AWA, SORNA, International Megan's Law, all that stuff, that I'm going to harm them. She's fully aware of my crime and she has no problems whatsoever. So regarding, the possibility of me not even being able to travel internationally because of the, the registration I have to submit to other countries. But I feel like it's a violation of my civil and constitutional rights based on religious grounds and the sanctity of marriage. And I'm kind of at a loss. I don't really know what the options are from here. And you don't hear much about this kind of a topic because it's a very fine niche in the system, so to speak.
That is a problem that most registrants aren't going to have. I have a little bit of familial experience, not from a registrant standpoint, but my brother is a musician who plays piano on cruise ships that belong to a foreign corporation and their foreign flags, and his wife is a UK citizen. And they have all kind of trouble getting her back into the country sometimes. And the different ports of entry are different from each other. Miami is pretty notorious, and that's where they always come in. You mentioned the religious rights, which would come under First Amendment because of the sanctity of marriage. I think the stronger rights that I see implicated are the actually under the Civil War amendments, the 14th and 15th Amendments, the travel right. Privileges or immunities in the 14th Amendment, and the familial rights, because that is fundamental. Those are fundamental rights, and the government is not supposed to impair a fundamental right, but by the least restrictive means, and they are supposed to have a compelling interest to do it. Of course, they always say, well, the state has a compelling interest in protecting women and little children from ogres like you. But, seriously, that's one size fits all thing is ridiculous. And the U.S. Supreme Court in Packingham versus North Carolina in 2017 expressed dismay. It wasn't before the court, but they expressed dismay that people who had already served their sentences were under all these compulsions and restrictions without any individual finding of their actual dangerousness. So I think they've laid, and that was a majority of the court. Actually, it was a unanimous decision, but 5 of them said the internet's like the public square. The other 4 said, well, maybe not. But the actual street and the actual public square is what's involved here, and a lot of the other types of restrictions that we see. My question for you, have you retained an experienced immigration attorney?
I have not specifically retained an immigration attorney yet. I've talked to several, to be honest with you, and the best advice that I've gotten so far is to reapply from the start again and get I guess you could say, for lack of better terms, a sexual threat assessment from a counselor, of which I've picked one out who's actually certified to testify before the United States Supreme Court, and he's only one state over. So I'm going to do that. But as far as an attorney right now, no, I haven't retained one in this next step.
Okay, well, you've had the advice of one, and that's interesting. I've never heard of the United States Supreme Court taking testimony before. They're a court of writs and appeals, but maybe there's some kind of Supreme Court certification for them. I don't know, but it sounds like I'm not the only qualification I have to speak to immigration issues is that which any criminal attorney ever since I'm trying to remember the case now, but just Padilla versus Kentucky, which came out several years ago, that every attorney who is going to enter a plea, a guilty plea agreement for someone who is not a citizen, has to have enough understanding to be able to explain what the immigration consequences may be, what the Supreme Court held in that case. And it's very interesting, and I think it's interesting for registrants because of this. Immigration consequences are not supposed to be punitive, but yet the United States Supreme Court reversed the conviction and set aside the plea and put him back to the condition he was in before, status quo ante, so they could try to work something else out. Because of the consequences, they considered the consequences, which would have been deportation in his case, it was a drug case, were they deemed so severe. And so if they're reversing convictions because of the person hadn't received adequate legal advice on immigration, I see the same thing, the same possibility for people who haven't received adequate advice on the consequences of sex offender registration, which are easily as severe. I mean, you may not be banished from the country, but you're banished from parts of it, you know, from zones and from all kinds of things, all kind of public life. The idea of starting over again with the application is interesting. It sounds like the two answers that you were given before were kind of each one is pointing at the other. That, well, we don't think you can come in this way because of that reason. We don't think you can come in that way because of this other reason. I think the first thing you have to deal with is the one about you not being a danger to your own children. And that may have to do, sometimes we see courts and government entities putting those, assuming that a registrant is going to be a danger to children, even when their registration offense had nothing whatsoever to do. And I'm not asking whether it did or it didn't, but the real point is them. And if it had to do with online pornography or something like that, you should be able to get the opinion of a certified counselor and make a record that you are not a danger to them and that she's fully advised of your record and so on, and that you do have some fundamental constitutional rights here. You're a U.S. citizen, you're married to her, you have children with her, and you have some fundamental rights, and you didn't have to give those up just because the state decided to impose this supposedly civil keeping track system on you that isn't supposed to be punitive. What could be more punitive than breaking up a family, other than taking your liberty altogether or your life?
King, what I'm going to do is there is an attorney whose name is escaping me, and I'm going to contact this person and pass that name on. I believe he's based in California, and he's trying to put together an action regarding this very issue. It's not something that affects a large number of people, but if it affects you, it's very important. So I will reach out to you at the phone number here I just recorded.
Right, and I would counsel persistence. This isn't something you can give up on. This is something you have to keep trying, and you want to proceed with good advice, and you know, keep your cool, and just be diligent.
So, and thank you for listening and for the call. The next person is in area code 207. We're going to try you again. You're on. Can they do that? Area code 207, you're on. Can you hear us? Area code 207 has now abandoned. Okay, we're going to go to the great peach state of Georgia. This is area code 770, my favorite area code in the entire country. You're on. Can they do that? Are we having any problems with the bridge, Andy?
Nope, we are not, because we just had a caller. So, I mean, it was working. This is on their end.
So, okay.
Hi, Larry. Hi, Mr. Alexander. Happy
Hello.
Second Chance Month.
Yes.
So I'm calling you from the great state of Georgia, where we just had a great constitutional victory coming out of our Supreme Court with regards to electronic monitoring, that registrants that were deemed a level 3 wouldn't have to wear the electronic monitoring post sentence. So once their sentence had expired, they were still required to wear that electronic monitoring for the rest of their life, and that was deemed to be unconstitutional, and that was given relief. I set that up to say what the community supervision is doing here in Georgia. I don't know if it's like this in every state, but the community supervision department has rules and restrictions that are outside of what the court ordered. They've like on parole, you've got 21 restrictions, according to the website, that they enforce that are kind of just the department enforces outside of what the court has ordered. So the condition number 19 on this is for supervised release for parolees in Georgia, says the offender shall be placed on electronic monitoring and may be required to pay a fee for this service. So what that means is everyone on the registry who's on supervised release for parole is required to strap on an electronic monitoring device regardless of their leveling. So you could be a level 1 low-risk offender, you're on parole, you're wearing an electronic monitoring device at your expense. I've talked to several men who are paying about $150 a month for their device, and they haven't been leveled, or they're leveled to level 1, they're low risk, but yet they have to wear that monitoring device as a condition of their release on parole. So my question is, can they do that? And what relief can these guys get to, I mean, they can't afford anything now that they're having to pay all this money to be monitored.
That is a terrible thing, and I see that. I practice in Louisiana, although I've passed the bars of California and Texas as well, and I'm admitted in 8 federal courts, including the U.S. Supreme Court. But mostly my practice is in Louisiana. I see that they make people wear these monitors, and they're charging ungodly sums for it. I don't see it being applied to everybody, which is what you're describing there in Georgia. Even for a low level, you're saying level 3, and that's for life. Electronic monitoring for life, everybody. That seems rather extreme. I do see some constitutional issues in that. There's a taking.
Well, the Georgia Supreme Court agreed with you, King. They said you can't do it.
What did they go on? Did they go on taking, or did they go under a Bearden substantive due process? Do you know?
Well, I read the opinion, and we're actually working with the attorney, and I feel woefully inadequate because I read it when it came out, and I haven't read it.
Yeah, and I did too. Bearden is out of Georgia, isn't it? Bearden versus Georgia.
Bearden,
that's a
yes.
case that says that person who has money has liberty, but person who has no money has no liberty because they can't afford to pay for the thing that the state says they have to have in order to be free. And this could be that if they're threatening you with, well, if you don't do this, you're in violation and you go back into the hoosegow. I assume that's the case?
So, well, in Georgia, it was a registry requirement. It was not a supervision requirement. And so the guy said at the end of his supervision, he told him, you can take your damn GPS and do things with it I can't say on a federal program. And he did it the right way, and he fought it all the way. And the attorney's name is Mark Urachek, and we've as a result of this, we didn't know Mark to begin with, but we've reached out to Mark in terms of possible litigation, and I would like him to explain it better, but it's a well-written decision. The GPS monitoring is ending in Georgia for those who have served the duration of their sentence.
And then it's interesting because the Georgia Supreme Court has already ruled, yet you have some of the local minders still trying to enforce these things. And sometimes they take the position, well, it hasn't, no one has litigated against us yet. But I don't know, that's the highest court in that state. What I've run into in Louisiana about internet, for instance, Packingham, they've had meetings about it. And what's getting back to me from probation and parole officers is that, well, we're not going to do anything about it because Louisiana hasn't been sued yet. And I said, well, we could certainly work on accommodating in that regard. They may need to be sued, but I think that maybe an opinion letter from an attorney who's familiar with this law might cause them to get in line, and then certainly they're on notice, and if they still balk and they're wrong, then that's when it gets into some civil damages and attorney's fees. Impact litigation is absolutely invaluable, and that's one of the great things that NARSOL does and encourages. And by impact litigation, we mean civil suits that are meant to have the broadest possible impact. It's very different from defending one criminal case at a time. You're able to have and as the previous speaker in the previous hour said, she didn't think legislatures do anything until they're forced to. And that's true at the administrative level sometimes as well, that until you hurt them in the pocketbook, they don't want to change their behavior. I think what really motivates them is not that they hate registrants, but I find that those kinds of functionaries are always worried about their potential civil liability and their political liability.
I'm gonna try to zero back in on Brendan's question, which what he's really focusing on is you go to court and you get a list of conditions imposed on you. And he is saying that the supervising authorities impose a whole plethora of additional conditions. And the answer, Brendan, is yes, they can do legally, they can do that. They can impose conditions. Supervising authorities are provided broad discretion imposing of supervision that are consistent with a bunch of factors, including to protect the community and are reasonably tailored to that offender's characteristics and don't unduly obstruct the rehabilitative purpose of supervision. The problem you're having is that they just take this whole boilerplate of a dozen or 20 or 30 or whatever his conditions, and they impose them on everybody without any individualized determination. And the courts are beginning to speak against that. They're saying you have broad discretion, but you can't just put a whole blanket of conditions on everybody without any individualization. So that, I think, Brendan, does that more closely answer what you were getting at?
It does, and it really disturbs me around the electronic monitoring because the rest are just inconvenient. This is hitting guys in their pocketbooks. You know, they're trying to make a living and making ends meet, but they're being charged an exorbitant amount of money just to be free.
Yeah, and that, electronic monitoring is a search also, and the U.S. Supreme Court citation on that one, this is another one from Glenn Girding.
That'd be Grady.
Yep. Yeah, that's Grady versus North Carolina, Glenn Girding being the appellate defender for North Carolina, if he's still in that job. But he's done great things there. That's where Packingham came from. He recruited Paul Dubling and others to do that, didn't he? There are two things, though, and one of the things Larry's already touched on is that, what I was going to say is that the different states may give discretionary authority to the minders, as I call them, but you want to look, that's going to vary from state to state, and I'm not sure about your state, but I've run into this in Louisiana when I have probationers complaining about all these conditions, and they're saying they won't show me in the statutory law where it says that. And I've in the meetings asked them, can you put your finger on the statutory law in Title 15, which is what is in Louisiana, where it says you can do that? And they kind of hem and haw, and then they say, well, he signed a contract. And when I get in front of the judge, I say, I asked them to put their finger on the statutory law that said they could do that, and they couldn't do it. And then they say he signed a contract. But, I went to law school, and I learned that a contract is something that's entered in by one's free will, not someone saying you will sign here or you will go back into jail or prison. There are vices of consent, error, fraud, and duress. This sounds like duress. And I've had judges back them down in individual cases. And I've had one client who was smart enough to sign his so-called contract and write under duress under his signature, because they told him he had to sign it. But that really didn't have somebody. Again, this goes to the theme of this hour. Can they do that? And I already gave the answer in the beginning. They can do that until we stop them from doing it. I think they're very vulnerable on this. They are conducting a search. They don't have a warrant, and they're making the people pay for it. So it's taking money, and if it's making people, of course, if you weren't poor before you became a registrant, you were very soon hammered into abject poverty by the fact of having to register and live with all that. So I think it's ripe for a Bearden claim, which is also out of Georgia. That's in the U.S. Supreme Court. That is a substantive due process right that says you're curtailing the liberty based on a person's ability to pay for things. And these people maybe are coming up with the money. Have you had anybody go to jail because they couldn't pay it?
So
that's always the threat, isn't it?
Yeah, we're going to move on past this question, King. I would push back just a tad bit. I don't think they have to have statutory law that says they can do things that are generally accepted for probationers. For example, every state practically that I know of says that it's not a good idea to have offenders congregating and having personal relationships with offenders that also have convictions. You can't find a law, at least I'm not aware of a law that says, but I think the courts that get routinely upheld saying that they can restrict associations. The question is, which associations can they restrict? Can they restrict all of familial associations? But they are afforded broad discretion within the contours of trying to keep the community safe, and they're individualizing these determinations that you need that. If you make obscene telephone calls, they probably would have broad discretion to restrict your phone access if that's your crime. But a person who doesn't have any problem with a telephone, saying that you can't have a telephone but other than a rotary telephone, that would probably be way too overbroad, and that would fall because there's no individualized analysis. But even though the judge didn't put a restriction on your telephone, I believe that if it's uniquely tailored to you because of your individual characteristics and it's trying to keep you from offending, I believe that the courts have resoundingly answered that they have that discretion to impose conditions on people. But what he's talking about is they're doing it to everyone without any individualized analysis.
Well, and it's not even just restricting their associations. Making someone wear a GPS ankle bracelet is no small thing, because that is a search of exactly where you are at all times 24/7. That is a huge overreach to me, and then making them pay for it on top of it. They're charging like $400 a month in Louisiana for this.
This is a developing body of case law where there's going to be a lot of stuff coming down on GPS going forward because of Grady. It's clearly a search, and there has to be all searches are not unconstitutional. Searches under
right, but they have to be reasonable. I mean, you have a right against unreasonable searches and seizures, and this seems unreasonable.
That's correct.
And if the state wants to do it, it's a question whether they could do it at all, even if they were going to pay for it. But for them to do it and then make you pay for it, I think gives you two different things. And I think they should be pushed back on for this. And I think there are grounds.
So, and I agree with that. And we're gonna, anybody who wants to get in the question, the line is open, *6 on your phone, and we're going to take another call here while others are getting in line. The area code is 815. It says Mason. You're on.
Yeah, hi. Earlier, I was trying to get back another question to Adele, basically kind of for her, but since you mentioned Packingham, it kind of relates. All right, here in Illinois, like for instance, my case has nothing to do with the internet. My case is from 2007, before the internet and the social media laws even started. So as the laws are stated, it says if you were convicted on or after, like 2012 or whatever it was, then that'll. So my thing is, like I just said, mine's 2007, so it doesn't apply. But yet, and the parole board did not recommend internet restricting as one of my restrictions. But however, when I get home here up in Ottawa, my parole agent forces me to get rid of my social media page that I had. Not that I was on it, but just for having one. She made me get rid of it, even though I registered it as I was supposed to do as part of my, as the law. And I registered my email page. I had to get rid of that too. So my question is, are they allowed to force me to not be any way, shape, or form on the internet? And if they can, what's going on with the Packingham case as far as, is it going to start falling down to all the other states or what?
Okay, I have a question before I can begin to answer. Are you talking about Ottawa, Ontario?
No, I'm in Ottawa, Illinois. There's a case
Okay,
going on
you
in
did say Illinois. Okay. All right. Well, that makes a big difference because you wouldn't have the benefits of the U.S. Constitution in Ontario, but in Illinois, certainly you do. It does seem as if the administrator doesn't have an understanding that the restriction cannot be applied retroactively as against you. Now, if there's law to that effect already in Illinois, that's great because in many states they haven't given up that particular point yet. They're still saying, "Oh, this isn't punishment, and so ex post facto does not apply." I don't know. It's a matter of state law, or someone has litigated it. Illinois is not in the Sixth Circuit, is it? It's in the Seventh, isn't it? The federal circuits.
Not for sure, but I know that there's a case going on, and I meant to ask Adele about it. There's a case going on by the name of, I think it's Jason Tucker, and he was piggybacking the Packingham case and basically challenged the laws here in Illinois as to try to be able to get on online and everything while on parole, not just as an offender, but while on parole, had the right to get on it using the Packingham case. So I meant to ask her because she's the one who filed it, and I don't know what's going on with that case, but yeah, I'm just trying to see what's going on with it.
I would say that that's very fertile ground, that internet is very fertile ground, and it's become so important to people's ability to make a livelihood and just to function in society. And I think the U.S. Supreme Court has already given us a wonderful tool for that and wonderful language. And we just have to get in the trenches and push and enforce it. In the Sixth Circuit, the federal Sixth Circuit, the Michigan case, the Doe's v. Snyder, even after losing in the U.S. Supreme Court, Michigan didn't want to get in line, and so now they're bringing the second wave, which is a big class action. They were already adjudicated for a lot of damages and attorney's fees for the first go around, and yet they're
1.8 million. 1.8 million for the
and they still didn't throw in the towel. They're still fighting it, but they're going to lose. And what the gist of Doe's versus Snyder was that additional restrictions came along in 2006 and 2011. And I think that probably swept the states because that pretty well corresponds with the presence restrictions and public registration laws that came into effect in Louisiana, not in that order. Public registries came first, but then exclusion zones came. And those are very onerous things, and those are the things that were found to be punishment by the federal Sixth Circuit, and the U.S. Supreme Court denied certiorari after asking the Solicitor General of the United States to weigh in with a brief, and the Solicitor General of the United States gutted one of the state's arguments that, well, we have to make this retroactive and we have to have these restrictions because of the money that's in federal SORNA, that's dangled for the states, and we'll lose that money if we don't do this. And the federal acting Solicitor General said, no, that's not. You're not going to lose the money. Federal SORNA doesn't have those things, and we don't require the states to have them. So
I preach that all the time. People, not that I'm advocating for the provisions of that Walsh Act, but they get all up in arms about something, and I said, well, that's not in that Walsh Act. Well, that's not in either. That's not in it either. And you're blaming the feds for something that your state people that you elected imposed on you, not connected with the Adam Walsh Act. That you're not required to have any residency restrictions. You're not required to have any employment restrictions by the Adam Walsh Act to reach a substantial compliance. Most of the stuff that people gripe about is not in the Adam Walsh Act. And in fact, there's a provision in there that says if the state Supreme Court, the highest tribunal, says that something's not enforceable, the state does not get penalized. They still get their money. But we're going to keep moving to the next call. Thank you for that, and feel free to get in line again if you have anything else. This is an anonymous person here. I have no idea, but you're on NARSOL in action. You are very anonymous. You have pulled off the impossible.
Thank you very much. I take pride in that. My name is Jeff, and I'd like to ask a question. Can you hear me okay first?
Yes.
Fantastic. Yes.
You have a good microphone.
Thank you very much. I'm using Bluetooth. Let me ask you this. Now, this question may seem very obvious, but I'd like to ask you to please, and I'll be brief, I'd like you to think about it my way for a moment. Is it possible, now, suppose I've finished all of my state-ordered sanctions. I've completely paid my debt to society and done everything that was required of me by the law, finished my probation, finished my sentence, everything. Now, it seems to me that they are requiring me to report for interrogation 4 times a year. I'm a tax-paying, law-abiding citizen who has fully repaid his debt to society, and yet I am required to report to the police station 4 times a year for interrogation to report all of my personal details. May I invoke the Fifth Amendment? May I simply show up and say, I'm here to register, but I invoke the Fifth Amendment? And the second part of my question is that, doesn't that mean that I'm somehow in custody? Because if I fail to show up to the police station, then I face legal jeopardy, substantial legal jeopardy. May I file a habeas corpus motion and tell them that I no longer wish to be in custody?
Okay, you ready for me to answer?
Yes, please.
Okay. Well, I think it would be a stretch to file a habeas. I think a court's attitude about a habeas was, well, habeas is for custody, and you're not in custody. What you're describing is something like a constructive custody because it is a limitation of your liberty. There's no doubt that it's a limitation of your liberty. For you to show up and for the quarterly interrogation, you call it, and that's an interesting way to put it. It reminds me of Doe versus Nebraska, which was a case in which substantial attorney's fees were paid, and there was no appeal on that. They brought a whole slew of constitutional issues, the plaintiffs did, and one of the ones they brought was Fourth Amendment search and seizure rights for people who were not on probation and who were not on parole. The judge was sympathetic to that issue, but did not make a ruling on it because none of the plaintiffs had actually suffered an intrusion into their home. It was just kind of a chilling thing. I don't know. It wasn't speech, so you don't really have that. But it hadn't happened to anyone yet that the officers had come into their home without a warrant. If they had, the judge was making it pretty clear he would find that to be a Fourth Amendment violation. And I'm drawing an analogy to the Fifth Amendment right to remain silent that you're talking about here. Of course, what you're going to you don't want to offer yourself up to be incarcerated on principle, I don't think. And that's what I could predict would happen, that if you invoke the Fifth Amendment, say, okay, I've presented myself here as required, but I'm going to invoke the Fifth Amendment.
Any dirt that you want, you will have to find out, for it is your burden. It is the state's burden. And furthermore, if I am under no suspicion of criminal misdeed, then how can they require me to report anywhere, period? Now, I'd like to say that I am a tax-paying, law-abiding citizen who has fully paid his debt to society, and nobody has the right to intrude on my quiet enjoyment.
We agree.
I'm absolutely sympathetic to that. Yeah, and I think that you state a civil case. Now, I have a question for you. Or do they have a form that requires certain things to be answered, or do they just launch into a general interrogation of all your inner thoughts and feelings and urges and inclinations? We have some people who are being subjected to polygraph in some parts of Louisiana. It just depends on.
As a condition of the registry, not as a condition of their supervision? They're required to take
people who are not on parole are being subjected to that simply because they are registrants.
Simply because
but not in my specific part of the state, but in an adjacent. The state probation and parole, which supervises this, is carved up into districts that are multi-parish,
okay,
which
but
is
you're,
like
you're
the county.
saying state probation parole. If they're not under probation parole, what does probation parole have to do with it, King?
Well, the state government, all of this is under public safety and corrections, even though the legislature says it isn't punishment. That's who they put in charge of it.
Okay,
Gentlemen,
so if you're registered,
that isn't.
let me jump in here. So if you're a registered citizen, you've done all your sentence, you get supervised by the probation parole department after you've totaled out all your time, because that's what this gentleman's asking here. He's done all of his debt.
Right. And
okay,
that's
so
exactly what the U.S. Supreme Court found very disturbing in a parenthetical paragraph in Packingham.
Okay, but are you telling me in Louisiana, after you've served all your debt to society, you continue to report to probation and parole in Louisiana, and you have to be polygraphed?
Not in every part of the state. It's just certain ones.
Are you telling me that in any part of Louisiana, after you've served all of your time, you're still told to come to a probation and parole office under what authority?
That's my understanding, that the ones in Beauregard and Vernon parishes are having to do that. Now, I will check with my client as to whether that's being done to people who are no longer on parole supervision. Now, it may be that it's only sheriffs and municipalities who are minding registration after that point.
That's
or
what
the
it should
state.
be.
Yeah, that's what it should be. But I'm not sure. That's what's being done. I will have to look into that.
I'm going to answer the other part of this call.
But I am sympathetic with Jeff. Jeff, I think he's thinking the right way about what his rights are and how this stuff goes too far. They need to be pushed back on, and I think he's on.
I'm going to answer the other part of his question about custody. As a general rule, for habeas purposes, courts have not been recognizing registration as custody, but there's an exception, and a precedential decision that was released back in March. Actually, it was released late February. The Third Circuit Court of Appeals, in the case of Jason Piasecki versus the Court of Common Pleas, Bucks County, Pennsylvania. They found in the case of Pennsylvania that since the registration requirements had escalated to such a degree in terms of the reporting obligations, that there was enough state control that in Pennsylvania it counted as custody. That's a small circuit that only has 3 states. I don't remember what they are, but I looked them up. So this is unique to Pennsylvania because their Supreme Court has said that the registry is punitive. So the federal court said, well, it's punitive according to the state Supreme Court, and they've said it's punitive twice. And they went through an analysis of all the things that's required of a person who's having to register. And they said it sure looks like custody to us because forms of probation require less frequent reporting. So, so as a general rule, it is not custody to be on the registry. So therefore, you cannot use habeas as a vehicle. But there is an exception now in this particular instance. If you are in that circuit, and if you happen to be, because my analysis is that you have to be not only in the Third Circuit, but you have to be in Pennsylvania, because the other 2 states, their Supreme Courts have not found their registry to be punitive. They have not found the things that the Pennsylvania Supreme Court have found twice regarding registration. So if that should actually spread to other circuits, you might be able to use habeas corpus as a vehicle. But right now, you're pretty restricted, and that is not going to be recognized as meeting the custody requirements for habeas corpus.
There's another type of writ that's been abolished in Louisiana, but some of the other states may still have a writ of coram nobis. And that is a type of writ to redress wrongs of a criminal nature for a person who is not in custody. That's potentially another way to proceed, but I think that your civil rights actions, your 1983 and that sort of thing, are probably superior cause of action.
We're getting way too detailed in the answers because of the time constraints. We got a queue
Okay.
full. We got minutes here.
Oh, good.
So I'm going to go.
Okay, lightning round.
Area code 410. You're on. Go ahead. Go ahead, area code 410. I think that's.
Yeah. Hi, Larry.
Yes.
It's Pat.
Hi,
Can you hear me?
We can hear you.
Hi.
Hello, Pat.
Well, hi. This has been very interesting, but also kind of depressing because it just, I don't know. I want to hear progress more. I mean, obviously there's progress, but and I'm sure other people feel the same as I do about this. It's just kind of overwhelming. But I write to someone in prison in Oklahoma. It's a private prison. I was wondering if anybody has done any kind of look or studies. These private prisons, first of all, they may not even be legal if somebody wanted to challenge that, and that's probably a big thing in itself. But I mean, I am just convinced this man I write to is innocent, and he just had a horrible case. There was really no strong evidence, and I mean, it's sort of like they can, in some of these kinds of cases, can just throw you in prison and throw the key away. And Oklahoma is one of these states where it's extremely hard for somebody who's been falsely accused to get help. The Innocence Project there, I think, is probably overwhelmed. And I don't know, has anybody done a study of like the false accusation cases and where there are more of them and where there are less, or where there's anybody that really feels like they're making any progress on those, or what?
I can tell you a little bit. Oklahoma has taken the dubious distinction of having the highest incarceration rate among the states. I know that because for many years it was Louisiana where I practice, and just in the last couple of years, Louisiana dropped to third place. We're beginning to see some parole reforms in Louisiana, and now Oklahoma is first. Mississippi is second.
Do you know of a study, because we're running
Louisiana's close behind? Well, there are studies, and I would suggest the Death Penalty Resource Center online, which has got all kinds of facts, and you'll see exoneration rates. The states with the highest, the largest number of death row exonerations are very populous: Illinois, Texas, and Florida. And Louisiana is fourth in number, but probably first per capita because it's a much less populous state than the other three that I mentioned. But that's just death row exonerations. In Louisiana, they've been convicting people non-unanimously, and still are, even though they outlawed it prospectively by date of offense. We still have old dates of offense, and we'll have them through the rest of my life. So that's kind of limited, But for Oklahoma particularly, there are people who practice there would probably be a better source of information.
So thanks for the question or for the caller and for listening. I'm going to try to hit two more really fast. So you're 561. Esther, you're on. Go ahead quickly.
Oh, hi. Yes, I'm a resident of Florida. And I just found out through Florida Action Committee recently that the Florida House of Representatives is putting forth a bill. It's called the Public Lodging Establishments, to require persons who have to register as sex offenders to report to the sheriff's office where they will be staying 48 hours before an intended stay at a public lodging establishment, regardless of how long they will stay at the location. In addition, the operators of a public lodging establishment who have a person required to register as a sex offender staying at or within 1,000 feet of their establishment must notify all guests staying there. Is this allowable?
I'm gonna do a quick answer.
Yeah.
Because we need one more person. They can do it until they're stopped. If they get that to the governor signs it. It's presumed constitutional, and it will have to be challenged. But they can do it if you guys let it get through your legislature and it gets to the governor. They can do it until they're enjoined from doing it by court.
And that's the thing.
But
this bill quite likely will never become law if the defense bar of Florida and any other group that's interested pushes back on it.
It's going to be
points out how ridiculous it is.
It's going to be the hospitality people. The hospitality is a big business
Yeah,
in Florida.
there you go.
And I've already talked to the Florida Action Committee. I think that they're rather than collecting all their statistics, they need to hammer the hospitality industry and say, you don't want this government intrusion. You don't want this responsibility. You're setting yourself up for a lawsuit. You can't let this pass. And that's where you're going to get the most trouble. Getting the hospitality people. If it becomes law, it will be constitutional until the court says it isn't.
And the Attorney General will probably be obligated by statute to defend the law against challenges. But I think ultimately they would lose because this in-person reporting stuff is one of the places they're vulnerable. And they have to show up 48 hours before you're plan to come to Florida and stay in a hotel. That's ridiculous. Louisiana has crazy laws like that, but you know.
I know. I never heard of anything like that, and I was just wondering: is this got to be unconstitutional?
Well, it's only unconstitutional if a court says it is. It's presumed constitutional.
Right.
All legislative actions are presumed.
Don't let them pass it.
Believe me, I wouldn't, and I don't think anybody else, in Florida Action Committee would. But I mean, how do you stop them? That's the only problem. I guess the hotels and everything else wouldn't want that either.
Lobbying, pressure.
Lobbying. But it enjoys a strong presumption it's passed. And
right.
The burden is on the challengers to show by the clearest of proof that it is not. So we are up on a hard break here. So we're going to. There's people in the queue, and we can, if King has time available, we can take these on the other side of the break. And if not,
I'll stick around. I'm a distressed traveler, and when I can get off, I have to look into alternative lodging. Because I left the keys to the condo back in Lake Charles.
I do not hear my lovely music, but I know it's time to go to break, so I'm going to do it even without the music. So we are listening to NARSOL in action, and we will be back after some important messages.
So this is probably my favorite slide. If it walks like a duck and if it quacks like a duck, guess what? It is a duck. Please stop telling us it's not a duck. Please stop telling us it's a civil regulation. Please stop telling us it's just there for the health and welfare of the community. It is punishment, pure and simple.
In a world where citizens are registered, their very existence is hated. The laws against them are unconstitutional. We have the Registry Matters podcast, an in-depth look into the laws surrounding the registry. Visit registrymatters.co or search Registry Matters in your podcast app.
Let me underscore that one of the worst fears that people have about sex offenses, that the people who commit them will not stop. All the research says that's not true. Here's my key point. People who are arrested for a sex offense are less likely to be rearrested than any other type of offender. Decades of research shows us this fact. Recidivism is a non-issue. It's confusing to talk about, but it's the exact opposite of what the Supreme Court claimed.
Hi, this is Brenda Jones, NARSOL Executive Director. If you're hearing this, you know just how important our work is to citizens across this country who struggle daily with the challenges of being on a public registry. You know what it means to wear that scarlet letter or to have a loved one wearing it. NARSOL is fighting for the rights of millions of registrants, their family members, and their children to live free of excessive repressive laws that keep on punishing long after their sentences are over. We are filing lawsuits challenging restrictions, and our volunteers are fighting in state capitals, not only to prevent new bad laws, but also to introduce positive change. We need you to continue our work. Have you joined us yet? Made a contribution? Go to narsol.org today, that's NARSOL.org, and click on Join or Donate. Do it today before you forget. Become a part of NARSOL's fight for your rights.
Please keep in mind, responses provided on the program are merely intended to offer guidance and should not be construed as legal advice. We cannot cover the specifics of any individual situation sufficiently to know what the most prudent course of action is, so NARSOL advises all participants to consult with an attorney in their jurisdiction to determine the best course of action.
So welcome back to the third and final hour of this special edition of NARSOL in Action. Thank you, Mr. Producer, for the lovely transition. Thank you for the lovely transition, and we're back in our final hour of NARSOL in Action. And we're going to have some board members here. And I don't know, Andy, how many people do we have on Discord that are going to be from the board? So I can introduce the people.
Brenda might be the only one. I'm going to unmute. We've been working on her sound issues, so she might be available on Discord.
We have Richard also. He's on the telephone, so we can get him back. And then, and I was hoping to have Robin. So, but we at least have a couple of board members, including me. So in this final hour, we're going to try to clear out those calls that were carried over, and then we're going to have discussion with the board, questions, comments, whatever you want to talk about. Again, like I said when we went to questions previously, please don't try to tell a story. We could spend a whole hour or the entire 3 hours hearing a story about some of these horrendous things. The stories are they're similar and they're tragic. And once we've heard the story, trust me, we've heard something very similar, and it doesn't change the problem. It's something that's personal to you, but it's affecting tens of thousands of people. Your son is not the only one who got convicted on a strict liability offense for having consensual sex with a minor. There's thousands more just like your son or your nephew. And there's a lot of similarity in this. The heavy-handed prosecutor. We know all that stuff, but what we don't know is how we can motivate more people to help us with solutions, and what we're doing that we may be doing not as well as we could do, and what we can improve upon. And that's why we want to have this interaction on a somewhat regular basis with the board and with our supporters. So let's go back to the the telephone because the queue is still full, and I'm going to take people I haven't taken. Those that have already had a question, I'm not going to be able to get back to you at this round. If you have a question for the board, or a comment for the board, but the people that I know we're holding over who have not previously been in, I'm going to take those right away. And King, are you here?
Yes.
All right, let's see if we can give some quick questions and answers. So area code 334, you are on. What is your question for Mr. Alexander?
Yes, I wanted to ask, I have a son that is a sex offender, and he has a 4-year-old child. What state would allow that child to live with the sex offender parent, or even attend a school, or to take the child to school or an event?
The question went by kind of fast. What would allow? Could you say that again?
Her question is, what state would permit a parent with a 4-year-old child? And of course, I think that that's going to require more detail than what we can get into. But as a general rule, the state has to have compelling reasons to separate the child from their parents. So is this a child that was not in any way related to the offense?
That is correct. The child was not related to the victim, the offense.
Okay, I would suggest if you're interested in shopping for a state that seems to be lighter on registrants than other states, I'm hearing good things about Kentucky.
So
okay.
And I'm going to tell you that's generally a service that we don't try to provide because there's so many nuances of trying to state shop. And if a national organization is encouraging people to go to a particular state, that state's going to look at their policies and their rules.
They're going to react, and then it's no good anymore. Ruin it for everybody. Yeah.
So, but
so we should maybe, yeah.
What I can tell you in addition to that is that you don't, if you have a state conviction, is this a state or a federal conviction? Caller, is this a state
it's
or a
federal
conviction?
because my son was. It was a federal because my son was in the military.
Okay, well then he has more options theoretically than people who are. If you have a state conviction, you're going to have to go through the interstate compact transfer process, and I don't have any qualifications to talk about how the federal system works. But on the state system, I teach that in terms of the interstate compact. But I don't feel qualified to tell you what the process is going to be moving from state to state.
Okay. I've checked several states, 4 or 5 states, and most of them say that the child cannot live in the same home. Now, this is the probation officers that I'm checking with for that state.
So,
and I've run into that in Louisiana, and to me, it's I really wish more people would litigate the issue because I think they're overstepping tremendously.
Well, are you checking with the probation officials that'll actually be supervising him, because you've identified he would not be under state control if he's got a federal conviction. I mean, he'd be under the state registry, but he would not be under the state supervision regimes. So are you talking to the right? Are you talking to the right supervising authorities when you're posing this question?
I do not know that.
Well, are you calling state officials? Are you calling state officials or federal officials?
State.
You probably would get better answers if you were to contact with someone who deals with military convictions and what type of supervision they're going to have. And I don't think calling probation officers would be a course of action. I would recommend to try to find out the answers to these questions. I would probably recommend calling. I know it's hard because you're trying to call and get screened through a law office and say, well, I've got a hypothetical situation. I've got a son who's got this problem, and we'd like to know if he can come to your state. And the call screener at the law office is going to say, well, do you have a case against you? So but the answer is you're going to get better answers talking to a legal professional that deals with people who have federal conviction, who have military convictions.
Yes, and you would want someone who practices in federal court and handles sex offense cases, and let them know. I mean, law offices don't want to give out free advice over the phone. I mean, because that's all he would do. Okay, but if you let them know that you want an opinion and you will pay for it, then someone may accommodate you.
Yeah, and I'm
Okay.
taking down your number. I'm going to try to call you because I may have an idea. Did you mind if I call you in the coming days?
I would love that.
So could I get your
I would
first
love
name?
that.
I've got your phone number right here. I'll put a first name with it.
Debbie.
Okay, Debbie. I'll try to reach out to you within a week.
Okay. Thank you.
All right. Thanks, Debbie. All right. Area code 850. You have not been on. Go ahead. What segment is this?
Hey, King. This is Joseph.
Ask the board here, but King's holding over for a few minutes.
Hey, King. Joe Pratt in Florida. I'm involved with Florida Action Committee, and some of my friends or some of your friends out there who like Ellen Boffman and Shauna Baldwin too. It was nice to see that Louisiana just re-enfranchised all their felons, even violent offenders. That was pretty nice, even on parole and probation. That was a nice victory.
Amazing things. Amazing things are happening in Louisiana. I had been screaming about the non-unanimous verdicts for over a decade, and we finally got that, although only prospectively. We're hammering away at death penalty. They're coming at us with a thing in the legislature right now that would restrict the ability of defense attorneys to interview witnesses, anyone connected to the victim, without writing to them and telling them I'm not the district attorney and so on. And we have to defeat that. So we're in the thick of it now. Our session is on right now, but thanks. We have made some good strides in Louisiana.
Right. And here in Florida with Amendment 4, of course, they excluded people convicted of homicides and sex crimes. But recently in legislation, they're trying to create a poll tax for convicted felons who can vote. So they're trying to still screw felons from voting in Florida, which is kind of heartbreaking, but that's just, And going back to the lodging one, because someone mentioned the lodging one, ACLU of main office in New York and ACLU of Florida have pro bono talked to the House and Senate Florida to not do that. So there was a thing from Florida Action Committee that ACLU main office in New York and ACLU Florida have teamed up to say, don't do that. Don't screw registered citizens from staying at lodging. So there is some legal help out there coming from the ACLUs, because I saw an email from Gail too. So.
Well, thank you for that. Thanks for listening. I'm going to try my best to find Will, who has been texting me, and Will promised to have him on top of the hour. We're almost past the top of the hour. So, Will, I need you in the queue because I can't find the number that you texted me from anywhere on the calling board. So I need a number in the queue, and I need you to text me so I can exactly get you on as quickly as possible. So, calling all Wills. So, all right, we're going to take one more caller while we're trying to find Will. Area code 340. You're on. Go ahead.
Yes. Good evening, and I'm very grateful for everybody that chimes in and does their justice for all of us. My question is this: my offense was committed in Florida. I moved from Florida. I live in a U.S. territory. However, when I visit Florida with my parents, the problem there is after 3 days, you report to the sheriff's office. After 3 days, if you stay more than 3 days, you have to go to the DMV to get a state ID. Now, the question is, I've done this before. I go to the sheriff's office, then I go to DMV. And when I go to DMV, everybody looks at you like you've got 3 holes in your head. No one in the whole state understands all of the legislation and the bills that get passed and all the things that they do to try to trip you up. I'm going to visit my parents again very soon. My fear is I'll go check in with the sheriff's office, and they'll always look at me, why are you even here? Because they don't know the law. And then I proceed to DMV, and then again, they're going to look at me, you don't need an ID, you don't live here, you live in U.S. territory. I'm not asking for legal advice, but what do I do to make sure that I'm not usurping the law, doing something illegal? Do I wear a cop cam everywhere and record everything I do?
That's almost what I was going to suggest. Document your efforts. That would be extreme. I mean, you want to, before you record people who don't know they're being recorded, you want to check into whether Florida is a one-party state, one-party consent state, or an all-parties consent state. as far as clandestine recordings. In Louisiana, you could do that legally, but that seems extreme. But most everybody's mobile phone that they carry has the capability to record conversations. But to bring a witness with you is a good thing. If there's someone who will come with you when you do these things, you want to document it and you want to keep a diary of it, and so that you can show your good faith in your efforts to comply with the law.
Well, I would say in response to the
Thank you.
caller, I would say in response to the caller, I've not heard that if you're only on a visitation status and not intend to become a student or become employed or become a resident, I've not heard that Florida requires you to get a driver's license to be temporarily present. What I have heard is that they will put you on. What I have heard is they'll put you on the registry and never release you even when you return to your state. That's what I have heard.
Yeah, I heard that about Florida too. That it's like the Roach Motel. You check in, but you don't check out.
So, but
correct.
So, all right.
Well, thank you very much. I appreciate it.
Thank you
all right,
for listening.
thank you.
I'm going to try to see if this is the person we're looking for. Is this Will? Area code 312. Does this happen to be Will?
Yep, I think it is.
Okay. Hello, Will.
Can you hear me?
Will is our wonderful asset in Illinois. I don't know the title, but I know that you're a leader in Illinois Voices, and Will has a publication that is just wonderful. So if you can have 2 or 3 minutes to talk about Illinois Voices and your publication.
Okay, well, I appreciate it. I appreciate you giving me the time. I am the executive director at Illinois Voices. We were working closely with Mark and Adele on these lawsuits and a number of other ones. And just a real quick question or answer to the question that people were asking about the task force. Illinois Voices has formed our own committee to try to get some legislation introduced to try to enact some of the recommendations that were made by the task force. The first one we're going to try and introduce is a grandfather clause to keep people from being forced to move if a daycare opens within 500 feet. So we are actively working towards that, the recommendations from that task force. So there's a lot of them, and really nothing will get done if we don't do it, because nobody else is going to jump out there and start introducing bills if we don't do it. So we are working diligently towards that effort. And then just a quick note about Lifetimes Magazine. We just entered our 2nd year of Lifetimes Magazine. Just yesterday, I shipped out our spring edition. We started Lifetimes Magazine, very similar to what NARSOL is doing with the humans on the registry. It's a way to showcase some of the positive stories of people who are finding joy and happiness in their life despite the burden of being on a registry. So we're not really an advocacy magazine as much as we are a lifestyle magazine. So we highlight stories of people who have success, and we also offer tips and suggestions on everything from, how to talk to people in a relationship to how to talk to people when you go to apply for a job, and then just some other things about messaging and vocabulary that people use when they talk about themselves. So it's designed to be a very positive and upbeat magazine. It's a full color print only magazine, and we publish it 4 times a year. In each of the seasons. And again, our spring edition just went out. So if anybody is interested in subscribing to the magazine, you can go to our website at lifetimesmagazine.org. It's $35 for a year. And again, that's 4 issues of and it's 34 pages, full color glossy magazine. So the people that are subscribing are emailing us back and telling us that they absolutely love the magazine and they love the concept. So we would love to have you guys check it out.
Well, it's a fantastic looking publication, and what we can do, Will, I suspect most of the people who are on this call have gotten where you're in our digest magazine and you're widely known. But I wouldn't mind if I can get a show notes a summary out to people. We could put something in here linking people to the magazine. I just need your help on that. What you want to say, but I'd like to do that for you, because we certainly endorse what you're doing and wish you the greatest success. And you are guys in Illinois are really doing some fantastic work.
We are doing what we can do. It's a struggle, like everybody in any of the states known, and everybody in NARSOL knows. It's a daily struggle, but I do feel like we're chipping away and making a little bit of progress. So I'm pleased with that.
Well, you've got so much going on that I can't even track it all. Scott sends me stuff that I file away and says this is Illinois, but I would be delighted for us to do more of these calls. There's more state specific because contrary to popular belief, there's a lot of crossover. It may not be happening like the lawsuit that we're conjuring up in Georgia right now for the sheriffs in Georgia. There's two of them that erected signs or required the offender to erect signs on Halloween Day saying no trick-or-treating. Well, you may not have that in your state right now. And you may say, well, what does that have to do with us? Well, it doesn't necessarily have anything to do with you at this moment. But those sheriffs in Georgia do travel to national conventions and they talk among themselves. And all it takes is those sheriffs saying, well, you know what I've been doing? I've been putting signs in these scoundrels' yards. And ain't nothing been done about it. And I get covered on Channel 11 News every Halloween. And first thing you know, it's happening in your state. Well, just this problem we talked about in Illinois with the mandatory supervised release, that may not be happening in your state in the same way. But there's a lot of transition because people move from one state to the other, and there's a lot of crossover. So I would like to have more state-specific calls, but I would like to see all the states promoting the calls because stuff does have relevance, even if it's not an immediate problem in a particular state. So that's what I'd like to invite people that have ideas, including you, Will. If you guys want to help put together one of these programs, we can do it.
Great. And the flip side is true to that as well. Not only does the bad news travel, but so does the good news. So that's why I asked Adele about, how this case can impact other cases, because when you listen to the words that the judges are using when they strike down these laws, those words and those ideas become fodder for other states to use. I mean, you look at what the state's attorney in Michigan just said, and her words are gold for being used in lawsuits. And the same with the Sixth Circuit case. You read the rulings and what the judges are saying, and you take that language and you apply it in another state and say, look, this judge already said this is punitive, or this is ex post facto or whatever. So I absolutely think it's great for states to be sharing that information with each other.
And we'll give you that forum. It's just a lot of work to put one of these together single-handedly, and that's why we went several months without one. But the states are invited. Those of you have things going on and want to share them, we can open this format up to you, and we can share the good things, because this like what happened in Illinois, that got me fired up in my state, because I say, well, gee, I've been hearing this for years. This problem has been a problem for years, and we didn't think it could be tackled. We didn't have anywhere near enough resources at the time this got on my radar. We now have a few more financial resources, and we now have a U.S. District Court opinion that we can probably get a lot of help from those attorneys that did the Illinois case to minimize how much work we're going to have to do. So we're all in this together. We're all working in this together.
Absolutely.
So, well, thank you, Will, and I'll be glad to get the word out. So,
all right, thank you for your time.
All right, now let's see, what board members do we have, Andy, that are ready to go live?
We definitely have Brenda. Yep, Brenda.
Hi, Brenda. Are you have a microphone open?
I think I do.
Sweet.
You do indeed. This is Brenda Jones, who serves on the board of directors, and she is the executive director, a very, very underpaid executive director, because she gets no compensation. She gets a lot of grief from people like me who give her a hard time, and others, and very little recognition. So you are recognized, and your shout out for all you do, in particular putting up with me.
I feel especially recognized. Thank you, Larry.
So, and we have Richard, if we can fish him out again, if he's in a quieter location. I had him, but the thing keeps bopping around because people are dropping in and out on the call. So he's gone off of the screen for the moment, but we can bring Richard. But we're looking for Richard. If Andy can help with that, I'd be gratefully appreciate that. There he is. I've got him. All right. So this is Richard, who's
good evening,
chair of the Conference Planning Committee, and he serves on the NARSOL Board of Directors, and he lives up in the great state of New Hampshire.
Except when he doesn't.
So except when he doesn't.
and that includes tonight.
And we have our communications director. She texted me and said she's here, and I haven't been able to find her. So that's very disturbing. How is she here, but yet I can't find her?
I have no answer for you.
If you're on the telephone, if you called in, Sandy, you need to do *6 so we can get you up here. If you're on any other method, I can't advise you on that because I don't understand all these other methods. So our tech guru will have to get you on if you're not on the telephone. So I don't see anything that looks like a number from 713 area. Oh, whoops! I think I just passed it. There she is. She is now live. You are now. I don't know how I kept looking over you. Welcome, Sandy.
Hello.
Glad
Are you hearing me?
We hear you just fine. And
Very good.
Sandy is our communications director and does so many things. I don't think that would even begin to cover what she does, but she does press releases and social media, and she also listens to me gripe and helps me with projects and doesn't get enough recognition. So thank you, Sandy, for being with us. And I think that's everybody that's here. If there's any other board member, you need to get yourself in the queue so we can have you here. So do any of the board members want to make a comment before we start asking for comments from the audience or questions? Is there anything you guys want to say about yourself? Brenda, I've tried to cover everything you do, but I'm sure I haven't done it justice. So.
Oh, no, as far as individually, no. I think you've hit that part pretty well.
Okay,
you had any
Richard.
broader things about the organization.
Richard, but you have anything you want to say in the welcoming comments before we take comments from the audience? Or?
I just want everybody on the call to come to Houston in June.
Well, yeah, they're all going to come. So, all right. And Sandy, did you want to make any opening remarks?
No, just that I'm glad to be here.
Well, glad to have you here. Okay, so we try at NARSOL to have an accessible board. We open our meetings. Very few people show up, but we open the meetings where the state affiliates are notified and they can invite people, and we allow observation of what's being said. No, we don't generally debate in a board meeting. We're having board of directors official board business. We're not usually debating the board the people that are observing, but you are free to observe our board meetings, and I don't know that any other organization does that. That's in this field of advocacy. But our board meetings are open. Sometimes but we are open so you can have transparent insight into what we're doing. So I've got a couple people in the queue, and if anybody who's out there listening would like to get in the queue and ask a question, *6. And we often receive emails and phone calls, and we would hope that we could get some of those where we could be answered more than one person at the same time. It's like, why don't you, Brenda, why don't we have a presence in DC? I mean, that's a question I get probably not a week goes by, is why isn't NARSOL in DC doing something in the halls of Congress? Why aren't we in the halls of Congress?
I would say we're not in the halls of Congress because we can't afford to pay anyone, and we don't have volunteers. It's probably one of my tenderest sore spots is that I like, as you pointed out, I do not get paid, and I have a day job, and my day job is in DC. So I spend from 8 o'clock to 5 o'clock, plus commute time, wandering in and out of DC. I work just off the mall, and it takes me about 15 minutes to get to some of the different government buildings where I could go and lobby. But we're not at a point yet where I could get paid to do that. And needless to say, I'm busy working, so I can't pop over there when the guys are there. So until such time as we either can hire a lobbyist or at least relieve me of my day job, then we just don't have the the volunteers or paid staff to accomplish that task.
That answers that component of the question, but I would like to dig a little deeper and say that in addition to that, the registry laws are operated by the states. I know we have the Adam Walsh federal guidelines and recommendations to the states, but there is no federal registry. So if the Adam Walsh Act were to be magically repealed tomorrow morning, the states would still have exactly what they have today operating. And it would be some time before states would be inclined to change that, because this is the way they've grown accustomed to doing business. So the battle is really in the states, not so much it is in D.C. in terms of the battle against the registry.
There definitely is that, which is a comfort on my part. There are routinely there's Adam Walsh reauthorization, which comes up regularly. Forget if it's every year or every other year. There are new national level problems, IML being a prime example, where we did actually try to get involved and do what we could to block that dang thing before it took effect, because of course that's much easier than getting rid of it when it's after it is. So there are things happening there, and I do think it would be worth our while to try to build up that presence, because I think our national lawmakers are suffering from the same problems that our state lawmakers are suffering from, which is they got no clue about the realities of what the registry is, who's on it, all the song and dance that we like to tell people about constitutionality and recidivism and all of those things. And just having those conversations and building those relationships could make a difference at the point that something does get introduced, or an opportunity for something to get introduced comes along. So I do hope that we will be able at some point to start building up that presence and those relationships in DC, so that we can be ready in the future.
So another common question is that a comment and a question we get is, you people always you're doing these Mickey Mouse challenges. Why don't you just file a challenge to bring down the darn registry? You talk about tonight on this phone call, you're going to do a challenge against the sheriffs. I mean, what the heck good is that going to do to try to stop the sheriffs from putting up signs? For God's sakes, you're wasting time and wasting energy, wasting money. Why don't you go after the big owner? Why are you wasting time with this?
Well, now that you've asked the question, you want me to give you your answer? Nah. Larry and I have talked about that one any number of times, and I wish with all my heart that there were that one big case that's going to take it all down. But as Larry already pointed out, the registry's in every single state, and say we could take a case to the Supreme Court, but it's likely, because that's how the Supreme Court operates, it's likely to end up being very narrow, and they could rule that the registry is punishment. But what that would do is, as it did in Maryland and some other states where we've had ex post facto wins, it wouldn't strike down the registry. Overturning Smith v. Doe would say it's punishment. And saying it's punishment is going to help anybody who was retroactively harmed by the Adam Walsh Act, perhaps, which is no small victory. But it, again, won't take down the registry. So there really isn't that big case that we all wish there was that is going to take it all down. And again, that's one of the reasons that we are focusing state by state, because our hope is that frankly, the state by state is how we will start getting things such as Packingham and what's the Michigan case? Those cases are, the Doe v. Snyder. Those are getting up to the Supreme Court.
So, well, and of course, I'm a little hesitant to say this with a conference coming on, because I could run the risk of having a pie in my face or something even worse. But
get ready, Richard.
Registration, in and of itself, a registry scheme has to be analyzed whether it violates the Constitution. The mere act of having a requirement to register in and of itself is not unconstitutional. It would be constitutional to have registry schemes that were not that didn't break any aspect of the Constitution. Now, I'm not advocating that. I'm just saying that since the courts would have to look at each scheme to see if it violates something that does raise a constitutional issue, you could have a very benign registry that imposed no restrictions, no requirements other than mailing in a form maybe once a year, and no disclosure of the person's address. And it would be hard to argue that that's unconstitutional because it's so benign. And that's what they said in Smith versus Doe in 2003, was that this scheme doesn't impose any disability restraints. If you look at the opinion on page 100, it says that's how they were able to uphold it. So you can escalate, as Michigan and many states have done, and you can cross over to where something is no longer benign and is very punitive, and practically every state has done that. But the mere act of registering someone, you could have a constitutional registry. So therefore, the courts can't say under no circumstances can you register anybody at any time, because we register young men for the draft, we register people who own guns, we register people to vote, we register on and on and on. And merely registering someone is not unconstitutional. But okay, so that was some of the common ones. We do have people in the queue, so I want to try to go to take some of those questions. It's *6 if you have a comment or a question for the board. If you want to identify a particular board member you're directing the question to, that's fine. If there's no particular direction, then we'll just have a volunteer answer it, whichever one wants to take it. So area code 214, this sounds like the Dallas Metroplex, and you have all kind of wind noise coming in. So go ahead with your question.
Okay. Yes, it is the Dallas Metro. Anyway, actually, my question had to do with in the last hour, I believe the lady's name was Pat. She was talking about innocence. And yes. A website was given, but I didn't catch the name of the website in regards to percentage of exonerations and such.
Did anybody happen to catch that? King was the one, and I don't know if he's still with us anymore.
Yeah, it did drop.
So that was Debbie that asked that question, and I didn't take the note on that. Now we do have a fabulous note taker that's working for NARSOL, and hopefully it was captured in the notes. And if not, it'd be in the recording and the playback, which Andy will have that available in the coming days. So you'll be able,
great. Okay.
You'll be able to listen to it on playback.
Oh, great. Thank you so much. And I will be seeing you all in Houston.
Hey.
Well, thank you. All right. So *6, you want to get into the queue, and we have this anonymous person that we were talking to earlier that I tried to answer his question.
Hi.
Go ahead.
Thank you. I hope that my microphone is not too loud and obtrusive.
We wish everybody sounded like this, so go ahead.
Indeed.
Excellent. Well, thank you very much for saying that. I'd like to thank everyone who works so hard and so tirelessly. We all know that you don't get paid, and we try so hard to call up our legislators when we're called upon. We thank you very much. I'd like to very briefly make 3 comments very quickly. First off, well, the first one was thank you, and I did that. The second one is this, and I wonder if you thought about this. You probably have. I'd like to ask the lawyers about if you have a civil matter, right? Because in 2003, the United States Supreme Court said this is a civil matter, not a criminal matter. Okay, with a civil matter, like a driver's license, if I decide that it's obtrusive or intrusive to me to somehow give all of my information to the Driver's License Bureau, I can opt out. I can say, you know what, here's your driver's license, stick it where the sun doesn't shine. I don't want anything to do with your driver's license, and simply not drive. The other thing is, if I get a civil judgment against me, I can always go and declare bankruptcy. In other words, I can opt out. Well, even if I'm called up for the draft and I have to sign up for that, which is a public registry, I could always say I'm a conscientious objector. So I have some sort of legal recourse there. So I wonder if you could respond to that. And very briefly, my third point is this. We all need to stand together, guys. Lately, there's been this movement to chip away at our numbers by saying the Romeo and Juliets don't count. Let's take them off. And the people who urinated beside a tree, beside the side of the road, let's take them off because they really don't count. But I tell you that every blacklist, every government blacklist is bad and wrong, and we have to oppose it and we have to stand together. Let's not settle for half measures. Thank you.
Thanks. So Larry, I'll take that last bit if you're probably the remaining attorney person on the call, close to attorney.
We don't have anybody that I see that's qualified. I'll just say that he feels passionately, so I'll try to address it. But go ahead with your answer before I have you forget.
Well, I was just going to respond to that the last part about chipping away. That's always a challenge in our advocacy work. I know that at NARSOL we make a point of saying as our public stance that nobody deserves what they get for being on the registry. The punishment comes elsewhere. The registry doesn't need to exist. So that's our straight out public direction. However, what often confuses people is that when we are going and talking to, especially talking to legislators, sometimes others, we can walk up to them. I should say this. We can walk up to a lawmaker and say, we don't think the registry should exist. But that lawmaker is not going to be able to turn around and abolish the registry. And so you have to work with them and find something that they can do. And that's the distinction that often happens is, you try to work with them. They're sympathetic. They want to see change. They know that the registry sucks, but they're not going to be able to introduce a bill that says we're going to get rid of the registry. They could perhaps introduce a bill that improves the lives of some. And of course, it's going to tend to be those low-level Romeo Juliets and slashers and that sort of thing. And it's a struggle because you want to help everybody, but you got to start somewhere. You got to get your foot in the door. And so that's the constant battle and struggle that we face as advocates. So Larry, in terms of the other part,
I'd like to expand on that, and,
sure.
and I think I can give a real-time example that'll help people. When you're dealing with lawmakers in terms of changing public policy through legislative advocacy, there are a lot of moving parts. It's a complex undertaking, and we don't live in a dictatorship in the United States. And you take a look at where you want to go, and then you take a look at where you can get to as a result. Those of you who just followed the First Step Act, it started and it was bipartisan because we recognize on this type of thing, you've got to have, to prevent vilification, you've got to get bipartisan buy-in. So you had a group of Republicans and Democrats trying to reform the criminal justice system. And they worked deliberately for a very long time and came up with a final product. But then at the last minute, it got hijacked, and I'm using that term as legislative. We use that terminology. It got hijacked by a group of conservatives in the United States Senate, led by Tom Cotton from Arkansas. And so you've been working on something for years and years and years, and you're trying to make positive progress, and you're trying to get buy-in, because if you're in the U.S. Congress, you've got to get 435 members of the House You got to get a majority of those, and then you got to get a majority of 100 in the Senate. So you're making concessions because everybody doesn't see things the life the same way as you do. So in the final journey on the Senate side, there were a group of conservatives led by Cotton who felt that the First Step Act went too far. Well, those who had been working so hard trying to make some improvement, they had a choice of just walking away from it. They can say, well, we're not going to get what we want. We'll just take our marbles and go home and we'll get nothing in the way of reform. Or they took what they could get out of the Senate into President Trump's desk. And the president did encourage, I think, a broader reform than what we got through his nephew, I think it is Jared Kushner. And we ended up with a very narrow reform, but it is a beginning. That's why it's called the first step. Well, the same thing with the registry. I would challenge anybody who's listening to this, go to your state capital and start shopping for lawmakers and tell them you would like to abolish the registry and find out if you can even get a sponsor. Now, a sponsor by no means assures passage. Only about 10% in my state of everything that's introduced actually makes it to the finish line. But just try to get a sponsor. And then if you succeed in getting a sponsor, start working that bill through the process and tell me how many concessions you have to make as you work it, because it's going to start out as abolishing the registry. And all of a sudden, before you get to the first committee, there's going to be extreme opposition and you're going to have to make concessions to not abolish the registry, but maybe narrow down the focus of your abolition. And by the time it gets to the end of the journey, you're going to be abolishing the registry for people who did virtually nothing. But I always ask people, if we can save some lives, if the registry is as bad as we say it is, and I do believe it's pretty doggone bad, if it's as bad as we say it is, should we turn our backs on whatever people we can save because we can't save everybody? Or should we save as many as we can and keep trying to save more as time goes along? Because like with the First Step Act, if all life as we know it doesn't end, and if we don't have a tidal wave of criminality, within 2 or 3 years, there'll be the opportunity to come back and expand the reach, and we can have a second step act. Well, the same thing with the registry. You've got to start removing some people because you can't abolish the registry. If you can get a registry abolition bill through your legislature, I'm going to buy up all the damn U-Haul franchises I can get, because there's going to be a massive migration to that state, and that there's no legislature going to abolish the registry, in my view. And unless it's a part of a nationwide thing that they all agree. Otherwise, they're going to become attractive places for registrants to move to, and you'd be crazy not to move there if you had the wherewithal to do so. And in terms of the other part of his question, I share with him completely. He's making the arguments that are dear to our heart. We all know that this is BS, that this is a civil regulatory scheme. No one doubts that. The problem is that the courts haven't recognized that there has not been enough well-developed litigation, and there hasn't been a desire of courts at the highest levels to hear this, because Supreme Courts generally get to decide what they hear. They're not obligated to hear appeals. You got one level of appellate jurisdiction, and the second level, the highest level, be it the state of the U.S. Supreme Court, they can pick what they hear. And they choose not to hear things that we sometimes would think, well, gee, they should have granted certiorari to that. They did not. But I don't completely agree with him, because you don't get to opt out of all regulatory schemes that are civil. Civil commitment for those who have mental disorders, and let's take out the civil commitment for sexual offenders, because that's a different beast altogether. But when you're civilly committed because you have a disorder that makes you dangerous to yourself or to others, that is a civil commitment, and you cannot opt out of it. You will opt out of it when they deem you no longer to be a threat, that you no longer meet the criteria for civil commitment, and when you're adjudicated no longer dangerous, that's when you get to opt out of it. So you are involuntarily committed to do something. And you don't, most people that I've known to be civilly committed don't generally run down and check themselves in and say, I want to be civilly committed. But that is a civil regulatory scheme. But in terms of the draft, you can claim conscientious objectors. We're not drafting anybody. We haven't since 1973. So all we're doing is registering people. And I don't know that one way or the other that you can conscientiously object to registering. That's something I don't feel qualified to speak on. But as far as I understand it, every young man between ages of 18 and 26 must connect with a selective service. And if they don't connect with a selective service and get their name in the data pool, they're not eligible for a host of benefits, including Pell Grants and financial aid. That's my understanding. I haven't been in that age since a long time. I was born during the Lincoln administration. So I've long since passed that age. But as far as I understand, that's what happens to young men. But we agree with you. We just the courts are not there yet. So hope that helps a little bit. Star
Wow,
6.
that was a long tirade, man.
It was a long tirade, but I feel passionately about what he said. He's right.
Yes.
It's crap. It's a punishment scheme called civil regulatory. And I have my own strategy about how I deal with that. I concede it's civil regulatory, and I use that to my advantage when I'm lobbying. I say, well, we can't do that in a civil regulatory scheme. We do. This is a civil regulatory scheme. The regulated entities, in most instances, can you think of anybody, whether it be the taxi drivers or the long haul truckers or whatever it is? Can you think of a civil regulatory scheme where they don't invite the regulated to be at the table? So I tell them, well, this is a civil regulatory scheme. You would like to hear from the regulated, wouldn't you? And they look at you crazy. And I say, oh, you're saying it's not a civil reg? I thought it was a civil reg. Which is it? So I use that to my advantage. So we've gone to, this is a caller from area code 770. And I know that area code. Who might this be? You're on NARSOL in action. Ask the board.
Hi, Larry. I signed up for this call just because of you, just because you're here, and really enjoying the show. And anybody who didn't do that, well, gosh, I think there's something wrong.
That sounds like one of my listener podcasts. Oh, that's too funny. So, well, that's very sweet of you to say that. I was joking.
Did you stage this call, Larry?
So, well, I did tell the story, I think, on the podcast that I heard Rush Limbaugh. He used to play that on his show. He would say that he had a little blurb he would play where a woman said, anybody who thinks he's not the sexiest man alive has got to be a lesbian. And I made this comment on the podcast about that Rush Limbaugh. So that sounds like it's been adapted from the podcast. So, by the way, tell me about the podcast, Andy. What is that thing all about?
That is a really interesting question. So it's a weekly program where you and I talk about news articles of the week, and sometimes we have some guests. We've had King on before, and we've had a couple other attorneys along the way. And then we also we try and find something interesting, like some legal theory, so that you can go off of one of your tirades and how to twist people in knots on how their logic is twisted, and try and make it a little bit of fun. We try and kind of pick on some people here and there. And I'm the stupid guy, and you're the smart guy. That's the podcast.
Is it that simple?
Yes. No, it's not, but yes.
So, well, I'm going to do something I didn't plan for in the script, and that was very nice of you to say that, and I do believe that's one of our listeners for the podcast. But I'm going to do something that I didn't plan for, but we've got an empty queue. So I'm going to ask anybody who has attended the conference, any one of our conferences, to give a testimonial. Why? What did you get out of the conference, and why should people spend their hard-earned dollars to travel to Houston? Anybody who's attended a NARSOL conference and has anything to say about what they took from it and how it's beneficial, and I would be delighted to hear that. And I see a longtime subscriber to the digest here, Aaron. Hello there, Aaron. I think Aaron's in Michigan. So Susan, Roger, all you regular attendees to the conference, get your star 6 and tell us why. And in the meantime, Richard, you're there making all kind of noise. You've been to a number of our conferences, and you're chairing the committee. What excites you about coming to a conference?
Well, first of all, Larry, I get excited just to see friends and catch up, talk about what's been going on in each states. Just to have that social experience, and also to be among people who can empathize and understand where I'm at in my life, and that I can offer that in return. So that's a big part for me. The other part, of course, has to do with learning new tools and understanding more about what these laws are about. I mean, this is a big process, and we all come at it from different perspectives at different times in our lives.
So, well, our Connecticut affiliates just jumped in the queue. Cindy, what makes you excited about a conference? You got a lot of great work going on
About
there.
a conference?
Not only well, not giving Cindy the credit. Cindy has just settled a lawsuit with Windsor Locks to do what, Cindy?
It repealed the child proximity zone.
And that was done through attorney Paul Dubling, right?
Yes, it was. And we're onward and upward, looking forward to our next municipality.
So, well,
We got 9 or
congratulations.
10 more to go.
Congratulations on that. And I'd like to have Paul on and do more of discussing about that. But you've been to a number of NARSOL conferences. I've seen you around in Atlanta and different places we've been. So what excites you about coming to see us in action?
Well, I personally enjoy drinking at the bar. No.
Well, not shy about saying it either, huh?
Exactly. 2 years ago, I think we named a drink the NARSOL. And of course, it's really a mocktail because it's sparkling water, cranberry juice, and pineapple juice. So yes, it's all the drinking I do at the bar. I agree with Richard about the fellowship. For me, that was the biggest thing, to realize that I'm not alone. I mean, I've been in this since 2015, and I started with just myself. And then a student out of Princeton, and then Richard. And so slowly we grew, but very slowly. And it was great to go to the conference, and it feels like family. I mean, I left my first conference and I went into a trench. I was depressed because it felt so good. And it's so tough out here doing what we do. So I think for me, it's a way to go and rejuvenate and remember that I'm loved and I've got a family and there's other people that have my back.
Thank you, Cindy. And not only that, you put on a great conference. I heard about it just a couple of weeks ago in Connecticut. So your healing conference. So.
Yes, we're continuing to get really good feedback, and the only disappointment was Sandy depicted it in her article that I think came out yesterday morning about the number of invitations who had gone out and the amount of people at the state level and in nonprofit organizations and people who do reentry services and the Department of Corrections, et cetera, who ignored and didn't show up even for a 2-hour VIP breakfast. And I think that's a shame, and it's arrogance. And anyway, it made me unhappy, but the conference was fantastic.
Oh, thank you, Cindy. We don't have any callers in the queue, so I think we're getting near the end of this segment. Mr. Producer, what do you say?
As you would say, let's fire this mother up. Let's shut this mother down.
So, all righty. Well, we will be doing, hopefully, I'm going to do my best to do one more call before the conference, and hopefully we can inspire folks to be on the call and to talk about the conference. This was kind of impromptu, I didn't plan, but there's a lot of good. I've gone to I don't forget how many. I missed the first couple, but I've been to most of the NARSOL conferences, and I feel good about every one of them. And so I am going to say thank you all for joining us. I do have a couple of people to make contact with. Hopefully I can get a written some notes out to folks and with some contact information for Adele. There won't be any contact information for King Alexander. He's a public defender, and he doesn't take the cases other than the ones that are assigned to him. So he's not able to be helpful other than just answer questions. So on that note, is there anything else our board members would like to say before we sign off? Brenda?
Larry, I want to say thank you to you. Thank you to you for having this call, and you and Andy, you do a great job.
Thank you.
Thanks to everybody who's stuck it through for the last 3 hours. Still quite a number of you on the call.
Yeah, over half of the people at the High Point are still here. So,
yeah.
So, so thank you, everybody. And so on that note, we're going to conclude this session of NARSOL in Action. And good night, everyone.
Good night.
Good night.
Q&A session is over.
Thanks, everyone.
Good night.
Goodbye.